Hello, folks, and welcome to another episode of Hangouts and Headlines. It is Wednesday, February 12th, 2025, and we are going to start just momentarily on what I think might well be the last episode in Hangouts and Headlines on the continuing saga of Blake Lively versus Justin Baldoni. Maybe not. I can't guarantee that in the future, but as we left off last week, halfway through the almost 200-page original lawsuit filed by Justin Baldoni and his team, we are going to pick up right there, but after we take a look at some of the media coverage of this particular case. So, like last week, because this is a long episode already, I know that I've planned out what may well be 4 or 5 hours at this point. I hope not, but it might be. I planned out a lot of stuff to talk with you all about today. We are going to skip the early Hangouts portion on the understanding that I'm going to need to take a break for my voice a little bit in certain points midway through, and I will check on the chat at that time, and you can let me know if you have any questions or comments then, and I will try to have as much Hangout time as I can with you all when we get there. But as it stands right now, thank you so much for being here, and if you want to support the channel at places like Patreon through memberships, super chats, or otherwise, it's more than appreciated, but do not consider it obligatory at all. I do this for fun. I do it because I want to inform, hopefully educate about things that I find interesting. And what could be more interesting than an open PR fight between two major celebrities that helps us get to the depths of how the media covers these things and how they can be manipulated on this and other stories. So with that all said, let's take a look at how Hollywood is treating things as of right now before we get back into the lawsuit. This was a Hollywood Reporter article I saw earlier today, and I thought it was very interesting because it matches a lot of my own thoughts, but not entirely. So, the Hollywood Reporter says, Blake Lively and Justin Baldoni march towards mutually assured destruction. The It Ends With Us duo seem hell-bent on controlling the narrative, while the press and public feeding off Hollywood's best feud are the real winners. I did a poll earlier in this video series that asked who the winners were. One of the possibilities was us, because we get all of this, as the kids, or Emily D. Baker might say, tea on these particular questions. And certainly we do. I don't know if there is any winner really as part of this story. Certainly the Hollywood Reporter has its doubts as well. The article starts off with a fairly tortured metaphor using the HBO Succession show on how one wants to control narratives here, but then asks the important question. Have you read the lawsuits instead of just the press coverage? Right? This is what I say in Hangouts and Headlines all the time. It's interesting that the Hollywood Reporter has this as one of their questions because they are, of course, the press coverage in that sentence. But going to primary source material is always so important with anything in your life, but certainly with respect to media reporting, not because they're necessarily deliberately trying to confuse issues for you, but because they are written by human beings. And human beings, including myself, come to any given story with a certain amount of bias, a certain amount of agenda, potentially intentional, but also potentially just kind of subconsciously. And so you want to get to the primary source material as much as you can so you can evaluate for yourself. You want to read multiple sources, multiple outlets. You want to watch multiple YouTubers on these points if you can. I know that's a lot of time, and not everybody has the commitment or desire to do that. But the more information you can get, the better your critical thinking and critical reading ability is going to be. Have you read the lawsuits instead of just the press coverage? Well, we're close to having read almost all the lawsuits. If you only read Lively's 80-page complaint, you'll be convinced that Baldoni is a fake feminist who made grossly inappropriate comments to his co-star, forced her into sexually compromising scenarios without consent, and then stealthily ordered a successful social media campaign to smear Lively for speaking out. Now, in fairness, you could also have only read the New York Times article. That's the reason we're talking about it here in Hangouts and Headlines in the first place. But yes, that's the way a legal complaint works. And it would be wise for places like the Hollywood Reporter and everyone else reporting on these things to understand that when you read one side's account of events, you're only going to get one side's account of events. The Hollywood Reporter continues saying, there's so much smoke witnessed by so many other named people who will doubtless be deposed that you cannot believe there is no fire. Again, not if we're treating legal documents the way that we should be. However, if you only read Baldoni's 224-page amended complaint, and we're not reading that one here in Hangouts and Headlines, we're actually reading the original complaint. My understanding is that the amended complaint mostly takes certain findings from social media about the dates that the New York Times put up photos and prepped its article that indicate that they were in cahoots, to use formal legal parlance, with Team Lively to put that article together, something that is absolutely understandable, but also obvious to anybody that read the timeline of when that complaint was filed in California and when that article went up. You'll be convinced Lively is a bullying diva who, aided by her husband Ryan Reynolds, manufactured a list of out-of-context harassment complaints in order to seize creative control of a film, forced him to sign a 30-point confessional, and then overreacted to social media backlash by slipping her accusations to the New York Times. Several of Lively's claims are disputed with additional purported texts, and it's easy to conclude that she misrepresented at least some of her allegations. Now, that's a problem when you're making allegations in the first instance. We talked about that, right? What we talked about last week in looking at this lawsuit, what we talked about earlier with respect to Baldoni's lawsuit against the New York Times, is that he does have good proof that certain aspects of what Lively has said are at least not the way that he remembers them, not the way that other people might otherwise describe them. There is a certain element of truth in the various things that have happened, so we do get that kind of perspective shift here, a he said, she said, that you might hear talked about with respect to harassment claims or hostile work environment claims, and that's going to be a part of this story. But when you are making allegations and somebody can look at you and say that is demonstrably false and have some evidence backing them up, that becomes a problem for the rest of your allegations when you don't have that smoking gun, you don't have that silver bullet, you don't have what is actually an assault claim. You don't even have like the injuries that we saw in Depp v. Heard that were somewhat difficult to explain in various contexts. You have basically a framework where you've tried to establish a hostile workplace environment with all of these little anecdotes, and if any one of those proves to be false, then we have to question the rest of the building that you have built with those anecdotes, and that becomes an issue if you're on Team Lively's side. Whereas, says The Hollywood Reporter, if you read both lawsuits were in process, you'll be convinced that you never want to work in Hollywood and should instead seek out a less treacherous career, such as operating mining equipment or doing underwater welding. Because what overwhelmingly comes across is a sense of exhausting falseness among a sprawling assortment of broken toy characters who default to complex machinations to get what they want instead of taking the simpler path of being honest, respectful, and sincere. I don't know that that's entirely accurate for what we're at least seeing Baldoni claim. And I'm going to get that pronunciation wrong. I've been told by a number of people that have watched my videos that when I say Baldoni, it's really Baldoni. I'm going to do my best to remember that as we go through, but I'm going to make that mistake because I have it set in my head as Baldoni. I'm not sure that that's entirely fair to his position insofar as he does seem obsequious, he does seem ingratiating in various aspects of his communications with Team Lively, but it also seems like he's trying to be respectful, he's trying to be quote-unquote honest. It just is in that cloying, ingratiating way that I don't perhaps like, and I agree overall with the premise of this paragraph that my overall takeaway from this story is that everybody in Hollywood seems to be out for themselves. Everybody in Hollywood seems to be kind of positioning themselves on a political axis to survive this tortured process of big money and making a product like a motion picture. And I wouldn't personally want to subject myself either to that as an environment or trying to deal with these various egos in play. So I wouldn't want to be Baldoni. I wouldn't want to be Lively. I wouldn't want to be Reynolds. I certainly wouldn't want to be working in the environment that Lively describes in her complaint in California or in her lawsuit in federal court in New York. That does look like a hostile workplace. What she has framed out is something that looks like a place that I wouldn't want to be. And so I like that the Hollywood Reporter, despite having its biases in backing of Hollywood, does acknowledge that this makes Hollywood overall look bad for everyone involved. If you're having serious conversations about astroturfing and crumbs or erasing telltale emojis from leaked texts, you've taken a wrong turn somewhere. And this, again, while I agree overall with this premise, that everybody's exhausted by this, that they're on their way to mutually assured destruction, the premise of the article, I think it's at least a little bit unfair insofar as once that New York Times article comes out, the question becomes, what do you do if you think that's entirely false? If you think this is an unfair portrayal of events, if you think you're being put upon, if you're potentially going to lose your career and livelihood, if you are Team Justin Baldoni and you're looking at this particular New York Times article, do you just not do anything in response? Do you just take it? I'm not sure that that's the right response. I'm not sure that society demands that of somebody who feels like he is being falsely accused in this way. Now, on the opposite end of things, maybe, as we've said in this space, everything is roughly as Blake Lively has portrayed it, and Justin Baldoni is the one that is kind of skewing the perspective on the other side. And then, yes, if you are being accused of these very bad things, we don't want people that create these hostile workplace environments to go free. We don't want them to otherwise be unimpeded by making everybody else's life a living hell. And that's why this particular case becomes one where reasonable minds can differ. Perspective really matters. And I would caution everyone to really take with a grain of salt anything you see vis-a-vis evidence in your social media timelines, vis-a-vis reporting like this, vis-a-vis what very passionate, very well-informed, very smart people might tell you about what happened here. I will tell you personally, I find Baldoni and his attorney's story more compelling. We'll see why as we go through the rest of the lawsuit as part of this video. But I'm not going to sit here and tell you if you think Lively's version is more compelling and has better proofs or is stronger and better positioned in the documents she has put forth, that she's right and Baldoni isn't in the wrong here. I don't think that we can make that assertion right here, right now, with what evidence we have before us. But again, I'm reasonable minds can differ, guy, so that's probably no surprise to you if you find yourself here. In the filings, Lively comes across like somebody who would order the launch of nuclear warheads over not getting a booth at a restaurant, whereas Baldoni seems like somebody who would burst into tears when his Tinder date fails to praise his unsolicited dick pic. You don't usually see that terminology in articles like this, but the Hollywood Reporter is a different kind of rag. Making any judgments about the actual validity of their complaints is the height of foolishness right now. There you go, Hollywood Reporter, with so much legal process runway still ahead. And yes, that's the main thrust of what all the reporting on this should be. It's not apparent to us what actually happened. We do have these kinds of different perspectives on similar events. So even when Team Baldoni goes out there with fairly good refutations of a lot of the points that Lively has made in her legal claims, you still note, as we noted last week, that there is a lot of truth. These things did happen. The word hot was said. The word sexy was said. And then it becomes how somebody interpreted it, what the context was, and we don't have the information in either set of documents to come up with that answer right now. Just examining a few specific accusations turns into peeling an onion of contextual shifts that may or may not matter. A slow dancing scene released by Baldoni's team has managed to turn 9 minutes of raw footage into Rashomon, while attempting to listen to Baldoni's entire 6-minute groveling voicemail to Lively has practically become a TikTok challenge. And again, I'm not looking at most of that evidence out there in social media right now on my own. I'm trying to stick to the legal documents. I know a lot of people are looking at those things. A lot of people are passionate about those things. We may do a video where we look at some of those aspects of things, but I honestly think it's maybe not the most useful expenditure of our time because you do get into this Rashomon type scenario. And if you don't recognize that particular reference, I don't blame you. It's a Japanese film from the 1950s, but the overall thrust is that the same people can see the same set of events and come away with completely different interpretation of what those events mean. When you see a cultural reference to Rashomon, that's what it means. Different people can see the same thing and describe it entirely differently. And also as part of that particular story, those people have their own interests, whether consciously or subconsciously, in seeing it the way that it benefits their own personal self-image themselves. So Rashomon is a good touchstone for this particular story. Different perspectives. Everybody that's looked at a legal case has followed a lawsuit or a trial, whether with me or with some of my compatriots on YouTube, know that even first-person witness testimony can describe things a little bit differently depending on who's doing the describing. Online sentiment, the documented obsession of both plaintiffs, has been a swinging pendulum. In recent weeks, it swung towards Baldoni for possibly one of the same reasons it favored Johnny Depp over Amber Heard in their 2022 defamation suit courtroom clash. The filings portrayed him as a super-sensitive creature, while the latter came across, fairly or no, like a bully. Now, Hollywood Reporter, I know you do this. This is the reason headlines first started out years ago, but you are maybe not describing Depp v. Heard in exactly the manner that I would suggest here. It wasn't just, certainly as part of the courtroom clash, that Johnny Depp came across as quiet and sensitive in his witness testimony, and Amber Heard defiantly did not. It is that when you look at all of the situations that were described by Heard, they didn't line up with what evidence was actually presented in court. So it wasn't a bully. It wasn't a man accused of workplace sexual harassment, it seems, doesn't trigger the socials quite as much as a woman accused of being a mean girl. It's that in that particular context, things were falling apart as the stories came out. And I know that that may be a difficult thing to grapple with if you're the Hollywood Reporter, if you're other media reporting on these things, because the landscape of events in 2022 was so tilted against Johnny Depp going into that lawsuit, going into that trial, that it's hard to kind of walk back what was undoubtedly early reporting in this and other outlets on that score. But I do think that what you're seeing here is not so much that Justin Baldoni is more attractive or more believable to social media users. It's that the stuff that we see coming out of Blake Lively and her team and the stuff that's floating up to the surface of social media and video interviews and otherwise suggests that the more likely true perspective is from Justin Baldoni's team rather than Blake Lively's. And on that score, one of the things I wanted to say that also came out here was that, as TMZ headlines here, Blake Lively says she likes to take control of movies. And this was a clip that came out with respect to an older Forbes Power Women's Summit, where Blake Lively basically says, hey, I would sign up to be an actress on these projects, and then I would get there and they would ask me to go and step on the pink mark on the floor and say what they want me to say, and that wasn't fulfilling to me. So essentially I would try to take creative control, and exactly the same kind of circumstances that Justin Baldoni and his team are accusing her of in their lawsuit. Now, I pointed out that this is a problem primarily because from a contractual standpoint, you have the ability to ask for those things. You have the ability to ask for an edit. You have the ability to ask for producer credit and the rights to do the things that a producer does on a film. But you run the risk of either losing money or being rejected outright, that somebody doesn't want to work with that person as part of the actor class, right? That you want to be director, you don't want to have a second voice making these choices for you, and you run the risk of rejection. So I say this, I actually had a wonderful conversation as part of this particular thread with my colleagues of Lawyers and Dragons, Alita at Legal Bites, and Ian Runkle of Runkle of the Bailey. There is still valuable content on X occasionally, folks. It's a hellscape most of the time, I will fully admit. But if you're interested in that, if you want to see Alita's takes and Ian's takes on these things, you can check out this thread, which I will link in the description on the podcast page to this video. But otherwise, I just wanted to point out that these things are being floated. There are also well-intentioned, passionate people that suggest that this is too much of a clip, that there's too much edited out here. And Blake Lively actually says she doesn't do this anymore and that she tries to be more upfront and transparent in her negotiations. But the issue at the outset is that there's now footage of her saying that at least historically she has acted in a way that is at least a little bit duplicitous to get her foot in the door and then take creative control of whatever project she is looking at. So she might have changed her stripes. This clip is not going to be the be-all, end-all. It's not going to be that smoking gun for Baldoni. But overall, it isn't something that's terribly useful to Lively and her team moving forward in this lawsuit. The other thing I would say on this, and I haven't seen spoken about a lot, however, is that this might also speak against Justin Baldoni in his position, right? I just said it lines up entirely with what his description of events is. And that might be because it's true. That might be because he's seen this video. And that's a useful thing, right? You see somebody saying something like this, you say, all right, we can frame the situation and the circumstances to look exactly like what she describes here. I don't really see people talking about that, but I do see people saying, why did he hire her if he knew this was out there? He might not have known. He might have known entirely. They might have found it out after the fact. We are talking about a full-fledged, multi-million-dollar PR war. And that means that neither side is going to be pure as the virgin snow. Neither side is going to be perfect or exactly the hero you want or need to defend on your social media timeline or otherwise. So we can't just dismiss out of hand that the Baldoni side, even if you agree with their description of events, isn't taking their narrative and making sure it contours nicely with something that they know is out there already. So there's all of these different aspects of these things, and that's before we start getting into the fact that they posted a website to include their complaint and a timeline of relevant events / evidence that they have to establish their narrative in that complaint. Now, a number of folks have asked me on this score whether or not I think that this is too aggressive, whether it is tainting the jury pool, whether it's a bad act on the part of the lawyers for Baldoni, and whether they can get sanctioned for this kind of thing. I've answered in comments to the earlier videos on this series, but I wanted to say here in video form that my answer is no, I don't think that this is too far. I do think it's aggressive. You don't usually see this kind of thing out there, but to the extent that this is just sharing public information in a way that is more accessible to more people, that in and of itself should be okay. Certainly the timeline of relevant events, which is an exhibit to the amended complaint, was essentially drafted for this purpose. It's not super useful to the court in this context in the early complaint phase of a litigation proceeding. It is done so that they can have this PR fight and that normies or civilians can see these kinds of things, but I don't think that goes too far in most instances. Obviously, Blake Lively and her legal team are likely to disagree on that score. But I don't think it goes too far as it stands right now. And I also wanted to point out as part of this little discussion that we are not looking at this amended complaint. I mentioned it earlier, but I think the amended complaint primarily talks about the evidence that was found after they filed their initial complaint with respect to the timing of the New York Times collaboration, we'll say, with Team Lively. And I don't think that really changes much of what they have to say in their lawsuit. But we might look at that again if it does prove to be more substantively interesting than our initial read through here of the first complaint. But honestly, I don't think you need 180 pages to tell this story. I certainly don't think you need a 225. That's going to be part of what I point out as we go here. We're starting on page 79 where we left off last week. If you weren't here with us last week, basically we covered the refutations point by point of what Blake Lively and her team had Wayfarer and Justin Baldoni and Jamie Heath sign up to with their complaint of coming to get her to come back to filming in 2024. Now we're moving on to what I would describe as the allegations of takeover, right? The question is why? Why would she do this? If she wasn't sexually harassed, if she didn't feel like she was actually operating in a hostile workplace, why did she do this? We saw floated at the end of the New York Times article that it might have been to take over the movie. We discussed that in the first video of this particular playlist. And here is where that particular discussion comes up in the legal documents themselves. Finally, in April and May 2024, Lively's extortionate threats, and note that word extortion and extortionate because we're going to see it a lot. That's the actual main case that Baldoni and Wayfarer are making here, that they were extorted by Blake Lively. She coerced Sony to allow her to create her own cut of the film at Wayfarer and Sony's expense, and despite Baldoni and Wayfarer's rightful protests. Sony's reasons for acquiescing to these beyond unreasonable demands were clear. Sony told Wayfarer in no uncertain terms that Lively refused to promote the film unless her demands were met. And this is a part of the extortion claim, right? So this is saying we have a contract with her. She is obligated to do these marketing things for us. She was obligated to film for us and make this movie on our behalf. And now she's saying she won't do those things that we have a contractual right to expect unless we give her something else that we didn't otherwise negotiate. That was the point of my comments to that video earlier, which is to say you can 100% ask for this stuff, but if you sign up on false pretenses, you can get in trouble for fraud or breach of contract or extortion, as is the claim here. Wayfarer, feeling increasingly cornered into agreeing to Lively's demands, attempted at least to require that Lively finally sign her engagement contract if her demands were to be met. And this I highlighted because this is an odd thing. This isn't brought up earlier in the document, at least not that I saw. If someone wants to correct me on that, please do let me know in the comments. But this is the first time where it's suggested that Lively maybe doesn't have a full contract. And this is certainly not the first time that it's suggested that maybe Justin Baldoni and Jamie Heath and Wayfarer overall are not running the tightest ship in terms of movie production, right? They're getting millions and millions of dollars to distribute this film on Sony's behalf. They're getting millions of dollars from investors to make this movie, and they maybe aren't following every procedure, dotting every I, crossing every T, that a good corporate counsel would recommend for these kinds of things. Certainly not having your actors signed up to a fully enforceable contract at this point in time. Potentially a problem for when the writer's strike hits and she goes off with her family. Potentially a problem here where she threatens to not promote the film. Maybe she doesn't have a contractual obligation at this point in time. There's a very complicated set of facts here that could change the overall leverage position of these legal complaints if there isn't a contract in place. Sony executive says, Jamie, I have Blank on here too. Blank has gotten Blake to approve the trailer we want, and Blake is calling Taylor Swift, to approve the song. She, of course, just reached out saying she's asking for time with Blank, her editor. We know it was conditional on signing a contract, but asking if you will reconsider. So Blank can release the trailer, and Blake does not change her mind, recalling Taylor Swift. So what this winds up sounding like is that Blake Lively is slow playing the signing of some contract or another that would oblige her to do certain things. And Wayfarer, perhaps late to the party on this particular score, is saying, we don't want this trailer to go out. We don't want these things to happen without her signed up to an engagement contract because our lawyers looked at us and said, are you crazy? You don't have your lead actress signed up to a contract to do these things? And Sony is saying, don't make that a condition to getting this done because we want to promote the movie. And Sony's a part of this story, folks. Sony is not appearing as either of the parties in any version of these events, but Sony acquiescing here, Sony kind of pushing Wayfarer to a point of uncomfortability is a part of this story. Now, they're probably not included because they're big, they're international, they have more lawyers than you can count. And neither one of these kind of celebrities want to engage at that level of litigation or get into that amount of trouble or burn their bridges in Hollywood overall. But they're a part of this story, and the fact that they are essentially siding with Lively here against Wayfarer is suggestive of either weakness at the distribution level and Sony Pictures, or, if we're being more generous to them, that they've heard the rumors, they've heard the whispers that there was sexual harassment on set, that Baldoni and Heath are potentially bad actors, that Wayfarer is not somebody to be in business with, and they are trying to essentially get around all of this without getting blood on their hands, without taking any negative press on their behalf. And as far as I can tell, Sony, for the most part, has stayed out of the limelight on this. And whether or not that's okay with you is going to be different for each one of us. But I do think it's interesting that you see text messages like this that suggest that Sony is also pressuring on Lively and presumably Reynolds' behalf. You can say that's because they want to stay close to them, the power celebrity couple. Other reasons, they're just bad at this. I don't know. But you can see some of this pressure here. If you guys don't want to play ball, you're going to delay and greatly hurt the movie, says Sony executive number 2. Good luck. That is only if you want to make this date. We're going to need to push. If only if you want your movie to be out there, if we want to market it, if you want to make some money on this, if you want to get some of your investment back, you're going to need to do what we say. You're going to need to play ball, as it were. Baldoni and the film's original editors were not even allowed to see Lively's cut, even if just to see how much of their work had been replaced. And then they used some text messages to evidence that. Just curious if you guys have peeked it or cut and if anything has changed. Editor number 2 says, I've just been told that we are not permitted to look. When did that happen? As per Sony. This evening. Wow, okay then, says Baldoni. The editors and director isn't allowed to look at an actress's cut. Got it. Well, here we go. We will keep taking the high road. Still believing that in a sane and just world, despite Lively's continued extortion, an actress would never be allowed to usurp his legal right as a director to create and release his cut of the film, he assumed that Lively's edits would simply supplement his work. Thus, Baldoni continued refining his director's cut. But as Lively threatened to refuse to promote the film or approve any related marketing materials, such as trailers, posters, and social media posts, a doomsday scenario for this major motion picture, Wayfarer and Baldoni were extorted into acquiescence to more and more demands. This included co-funding, together with Sony, a friends and family screening of her version of the film, which they had not approved or even seen, entirely at Lively's insistence. So again, Sony's a part of this story, right? Sony is saying, Wayfarer, you need to go along to get along on this. And one aspect of this story is that Sony Pictures undoubtedly has more experience dealing with high ego people, dealing with difficult actors, actresses, and directors, if we're being honest, to get movies made, and is looking at this as a thing that they can solve by allowing a cut and having the cut reviewed by audiences, and this is all going to work itself out in the end. So that's probably why they are kind of displaying this amount of weakness, but obviously things got out of control. Ultimately, Lively replaced the film's editors with their own choice, an editor often used by Reynolds, and the film's editors had to be let go. And here, the reference to an editor often used by Reynolds, that's damning in certain respects. It's also probably not the complete picture. It's the same kind of accusation that Lively levels at Baldoni with respect to him hiring his friend to be the gynecologist in the movie. Chances are the editor often used by Reynolds is someone that has totally reasonable certifications to do editing on a motion picture. So yes, it's a friend of Reynolds, and that's a part of trying to frame this particular story as Lively and Reynolds taking over. That's fine. But probably not too useful from a legal point of view. Wayfarer and Sony found themselves in the unprecedented and uncomfortable predicament of having two competing versions of the film. I don't think that's unprecedented for what it's worth. You can certainly say that in a legal document like this one, but I have heard certainly tale of movie makers, studios putting out two different cuts in order to evaluate things on an almost A/B testing basis between test audiences. We've seen discussions of that even with pictures coming out this year. Things like Captain America, Brave New World has had multiple cuts, multiple tests done. Some of those are undoubtedly not going to be entirely director-directed. Some of them are going to be done by studio creatives, and others, I'm not sure that this is entirely unprecedented, but it's certainly uncomfortable. One made by the film's actual director, and one made by a person with no contractual or creative right to even approach the editing bay, let alone make her own cut. Now, there's certainly no reason to believe she had a contractual right. I'm not sure what it means from a legal perspective to say she had no creative right. Like, you're already covering that with no contractual right. As a creative right, that's more of a human being's right. She probably did have a creative right to approach the editing bay, but not a contractual one. So again, we got a little bit of lawyering. We got a little bit of that. We're going to make everything sound like the end of the world. Everything sounds apocalyptic. That's not unusual. That's not bad. That's good advocacy in certain respects, but I do want to point them out because they use this language and it's maybe a little overbroad for what we're talking about. But in light of Lively's threat to withhold promotion of the film, as well as her thinly veiled threat to end Baldoni's career with a slew of false accusations, the studio reluctantly agreed to do an official audience test of both versions, again at Wayfarer and Sony's expense. This decision was made on the understanding that Lively had agreed with Sony that if Baldoni's director's cut tested higher, she would drop the matter and fully cooperate so that Baldoni could finish the film without further interference. And here's what I mean when I suggest that Sony is probably looking at this as a situation they've dealt with before. They've got creative differences. They can't afford to lose whatever investment, time, resources, or otherwise they put into making this movie. And so if you've got these creative differences, you've got a high status, high ego actor, actress, director, whoever it might be. You run these competing cuts, and then both sides acknowledge that the losing cut is just not going to be the final cut of the movie. And yet, when we get to the testing, we see it described as, in our key demo, editor for Baldoni says over 20% higher in excellent and 15% higher in the definite recommends. That says it all. The only group she went up within is the excellent category was men, and they are absolutely not our audience. And that's only because she focused more of the movie on herself. And men like to look at Blake Lively. Men are such pigs. It's an interesting text exchange between Justin Baldoni and his editors. Anyway, this particular concept here suggests that Lively lost on the competition. Not surprisingly, however, this lawsuit says Lively reneged on her promise and insisted that her version be released to the public instead of Baldoni's cut as director, even claiming that the book's author, Colleen Hoover, would refuse to promote the film, as well as if Lively's version was not chosen. Sony called to tell Wayfarer that neither Lively nor any of the cast would promote the film unless Lively's cut was used. Baldoni was forced to choose between killing the film and his own career by insisting on his own creative vision and rights or putting out a version of the film that Baldoni knew could be still important to domestic violence survivors, even if it differed greatly from what it could have been. Baldoni reluctantly chose the latter and stood down, allowing Lively's version of the film to be released and promoted. And again, this is part of an extortion claim, right? So he is going to need to prove that he was threatened with things that were wrongful, that were illegal to threaten him on, and that he gave up something of value in response to those threats. Here we still have the continuing issue of him acquiescing. I said last week that you could point out all the times the phrase, and so we acquiesced, or so we allowed for Lively to do something, were used in this particular document. That creates a problem from a legal perspective, that you have regrets. You don't like how this turned out, but you otherwise acceded to their complaints. You agreed with Sony. Sony's driving the bus here in certain important respects. And so by the time you get to this point, are you really being extorted? Are you really being forced on this? Or are you just conflict averse? And that's a part of the problem with this particular set of laws overall, is when extortion starts and ends. We see that a lot with lawsuits, right? If you've threatened to file a lawsuit, that's undoubtedly your right to do. But if somebody says, all right, I'm going to give you a settlement payment to make sure you don't file that lawsuit, is that extortative? Probably not, but it can be in certain contexts if you're threatening something that you know to be false, if you're doing something otherwise unfair. I'm not sure this lawsuit, I'm not sure this document gets to that place in the world. I'm not sure that they make their case completely here. Reasonable minds can certainly differ on that as well. Eventually, with the key demographic being the focus, Sony and Screen Engine, the audience testing company, convinced Lively to put back as much of Baldoni's edit as they possibly could. And then we have some more text messages. By June 2024, Lively was dictating much of the marketing for the film she had stolen from Baldoni and Wayfarer. More text messages. Over Sony's objection, Lively insisted on screening her cut at Book Bonanza, Colleen Hoover's annual convention hosting authors and fans from around the world, an event that Baldoni had long been excited to attend. But Sony made it known to Wayfarer that, per Lively, Baldoni could not attend, notwithstanding the obvious promotional and PR risks. Lively appeared on a panel alongside Hoover and other cast members, icing out Baldoni from this critical event for his own film. He was not even allowed to review the final cut before it was shown to the world. And again, that's very bad. Is that illegal? Probably not on its face. You have to create this extortion case, just like Lively has to create the harassment case to get to retaliation on the social media piece. So you have to make it something that is bad and that you were threatened to have it out there in the world. But I'm not positive it's illegal. And again, Sony is a part of this story as much as Lively is. It's notable that they aren't defendants on this particular case because you don't want to bring in essentially your boss into a lawsuit like this, you don't want to burn those bridges. But they do appear to be essentially helping Lively with the positioning that she is taking on this score. More text messages. By July 2024, Baldoni was completely locked out of the film's final cut. By virtue of his role at Wayfarer, he was permitted to give notes as a studio. Despite his personal feelings, he redirected his thoughts to focus on the one positive. The film, years in the making, was very close to being seen by the world, even if it was no longer his film. And this is where you get the quote that we saw in the California complaint. We made a beautiful baby together. The baby might not grow up exactly who we thought to be, but it's still beautiful. That's what I'm holding on to. Very proud of us. The last I heard, says his editor, was that she was putting back a fair amount of our version, just not sure what that entailed or to what extent. I guess you'll find out today. It's really remarkable, right? That Hollywood Reporter paragraph about not wanting to be involved in Hollywood really comes out with all of this. Lively was still not satisfied. She continued to extort Wayfarer, Baldoni, and even Sony, threatening to abandon her contractual obligation. Okay, it's a contractual obligation now, so maybe she signed up to what they needed her to sign up to at some point, to promote the film or prove marketing materials if she wasn't awarded a producer credit. And though Wayfarer had refused long ago to accede to this request when it was made during initial negotiations, Wayfarer now had its back against the wall and again had to concede. So here's this first reference to that actually being requested in the initial negotiations, right? We saw the TMZ headline, we saw the video clip described on Twitter/X about her wanting to suggest that she's just an actress and then taking additional creative control when she gets onto a project. But this actually sounds like the right step was taken to say, I want to be a producer on this film, and Wayfarer says we're not interested in having that relationship with you. That's better than just ignoring it and saying, I'm going to come up with this later on. But if you agree to not be a producer, saying, I'm not going to do any of the other things that I've agreed to do for you unless you give me that producer later on, can be blackmail, can be extortative, can be this kind of thing that makes a legal case like this one. That still wasn't enough. Lively later sought the coveted PGA mark on her producer credit, a certified designation licensed by the Producers Guild of America to identify producers who have performed the majority of the producing work on a motion picture. Lively demanded, again with extortionate threats, that Baldoni, Heath, and other producers and department heads send letter to the PGA in support of her certification for the PGA mark. Despite unanimous recognition of the absurdity and the unmistakably extortionate threats, and you've said that twice in this paragraph without actually detailing them, Sony and other parties, despite being adamant not to support Lively's demand for the unentitled mark, ultimately acquiesced and submitted letters of support. I think if Wayfarer goes under and Baldoni and Heath otherwise have trouble, their new studio should be called Ultimately Acquiesce. However, Wayfarer and Baldoni firmly resisted, which is a first for them. Because Lively did not perform the duties of a producer and therefore did not merit the PGA mark, a distinction highly valued and taken seriously within the industry, Wayfarer and Baldoni refused to devalue the contributions of actual producers on the film and elsewhere who merited the mark, and were unwilling to misrepresent Lively's contributions to the film. Well, if that is true, good for them. Having been forced in the face of extortion threats to concede to Lively's every demand thus far, they believed it would be dishonest, unethical, and unjust to producers who rightfully earned the mark to falsely represent to the PGA that Lively had fulfilled the requisite producing responsibilities. In response, Lively instructed Sony to tell Wayfarer and Baldoni, how do you like that sentence, right? In response, since Lively's apparently giving the cold shoulder to Wayfarer and Baldoni, she told Sony to tell them that any goodwill left between us is done. That's its own paragraph in this legal document. It doesn't sound so much like a threat, but they describe it in the next paragraph as eventually, in the face of persistent threats and extortion, Wayfarer and Baldoni were left with little choice but to draft and sign a letter of support on Lively's behalf. But not before Heath sent an email to Wayfarer's attorneys documenting that he and Baldoni were signing the letter under duress. And this is something that clients do. This is something that people that interact with lawyers do, is say, hey, I'm going to send you this informational letter. Jamie Heath, to presumably his counsel, as described above, I'm writing to you all regarding a letter that I wrote on behalf of Justin and myself, addressed to the Producers Guild. As you know, we received a request to write a recommendation on behalf of Blake for her to receive the PGA mark. This was a request that we feel was unreasonable and cold-hearted. Essentially, the movie It Ends With Us has been taken unjustly from Justin as a director and essentially from Wayfarer's control due to the extortion of Blake. Without going into all the details of the events that have transpired over the months, and here again we get that same Rashomon perspective shift, right? They're saying it's because she's extortionate, she's seizing control, she's doing all these bad things, she's an egotistical actress that's overstepping the lines of her role. She says it's because they were bad guys on set that created this bad circumstance. They created a harassing environment, and that's what they don't want to share with you, Mr. Lawyer. Justin and I ended up agreeing to write the letter due to feeling trapped. She continues to hold a threat over our heads, and every time we try and hold the line, she uses that threat either directly or indirectly to get us to fold. It would be a shame if this information were to get out there. Make no mistake, I am not suggesting that we were forced literally to acquiesce, but given the high profile of the movie, the partnership with Sony, the amount of money invested, and the need to complete the movie, we have written a letter on her behalf, omitting the truth of how and why she was able to contribute in the ways we listed. So they did ultimately write this letter for her. He wants to tell his counsel, if it ever comes up that I'm trying to defraud the Producers Guild of America, that I did not do it intentionally and I was essentially forced to do it. But again, we get to this, what is forced? What is extortion, right? Because it's not described as she's going to reveal to the world that I have been sexually harassing folks or otherwise. It's because of the high profile of the movie, the partnership with Sony, the amount of money invested. These are all important things. These are all things somebody should not lose for wrongful acts. But do they rise to the level of extortion? Reasonable minds can differ. There is nothing to do with this letter now. And I have to tell you, if you're ever interacting with a lawyer, we do appreciate this line. The line that says, great, why did you send this to me? Are there any action items for me right now? We're trying to avoid malpractice, trying to make sure that we are advising you properly. There's nothing to do with this letter now. It only serves as a way to memorialize why the PGA letter was sent in the first place, should we ever need to explain it. Thank you, Jamie. And the lawyers themselves are writing what we call memos to file on things like this in terms of setting a documentary record if there were to be a controversy later on. So this isn't that unusual, but we do appreciate when you tell us that there's no immediate action item. And then they have a copy of the letter they sent to the Producers Guild. From the time Blake was brought on, she has been an instrumental voice in many different aspects of the making of the film. Her contributions have been impactful, and she was consulted with many of the casting options. She helped to refine the script. She redesigned her own wardrobe, as well as gave notes on others. She contributed to the production design and set decoration and had influence on how many of the scenes were shot. Blake has been very involved in the post-process as well. Yeah, undoubtedly. She's had an active role in the edit, the sound mix, and has made decisions on the music selections and score. Since contractually she began the movie with an EP credit, our earlier submission to the PGA did not include her as a named producer, but we both feel her contributions have warranted the revised credit and consideration for the PGA mark on behalf of Wayfarer, it's Baldoni and Heath. As the premiere of the film approached, Lively made good on her promise and instructed Sony that she and the cast would not participate in any marketing or promotion of the film alongside Baldoni, in spite of Baldoni and Wayfarer's acquiescence to all her demands. She made certain that Baldoni was removed from all artwork for the film, posters included, and stripped him of his A Film By credit. Now that's interesting to me. Again, as a business lawyer who doesn't work in the film production industry, I would assume that something like a film by as a credit is contractually negotiated. That should be a part of Baldoni's contract with Wayfarer on these particular scores. Now, maybe they aren't documenting that properly. They aren't dotting those I's and crossing those T's because they own the studio that's making the movie and they don't really feel like they need to worry about those things, so it's easier to strip it of him. But as a contract guy, that's the kind of thing where I say, what do you mean stripped him of his credit? How do you do that? Yes, you could take it off the edit, but then you have a breach of contract kind of complaint. The other cast members also unfollowed Baldoni, creating the false impression that Baldoni had done something wrong. And here's another area where they aren't dotting their I's and crossing their T's. It's probably, in the year 2025, a good idea if you're making something that is public-facing, like It Ends With Us, to have as a provision in your contracts that you aren't going to change your status in various social media capacities if it's going to have this kind of story come out. This is the things that you put in contracts section of the lawsuit. On information and belief, Lively induced the other cast members to shun Baldoni in an early attempt to give fans the impression that Baldoni had committed an egregious sin, something so egregious that no one wanted to even take photos with him or have him around. And again, like we talked about earlier in this video series, on information and belief is where folks say, we don't actually have the evidence to prove this, and you're only supposed to say truthful things to the court in this context, but we have reason to believe this is the case. So they don't know whether Lively induced the other cast members. They don't know how she might have induced the other cast members, but they think that because of the way the cast members wound up cutting off Baldoni on social media and otherwise, it was due to Lively, that only when they kind of had conversations and communications with Lively did this happen, that they can have that information and belief, even if they can't prove it before discovery, because discovery is the part where you go through everybody's files and figure out what is actually true. Lively was leaving what she had earlier referred to as crumbs, a social media strategy she had learned from a close celebrity friend. Who? We don't know. To give fans just enough to allow them to come to their own conclusions. thereby launching an army of detectives that, on information and belief, Lively hoped would turn against Baldoni. And I'm not entirely sure why you need information and belief for what Lively's purposes might have been there, but hey. The unfollowing of Baldoni by cast members and even the author of the book, who had a long-standing relationship with him, was done without warning or any communication from them, in stark contrast to the warm praise and appreciation cast members had, until that point, always showered on him. For example, Isabella Ferreira, cast as young Lily, exchanged grateful texts with Baldoni during and after her filming stint, which included a number of scenes involving intimacy. "You did awesome today," says Baldoni. "Thank you so much. I'm so excited. Thank you for being a great director and being so wonderful to work with already. Let me know whenever you need me for anything." "So kind. More to come. You are going to kill it." And they continue this, again, effusive, ingratiating kind of text and messaging exchange, which, as the Hollywood Reporter suggests, might make anybody outside of this particular bubble a little bit reluctant to interact with. But they continue with that. And again, I'm not sure this is the greatest piece of evidence that they were friendly, and then they weren't. Tellingly, Ferreira worked with Baldoni when Lively was not on the set. It was not until Ferreira spent substantial time with Lively during film promotions that Ferreira felt compelled to shun Baldoni in repudiation of her warm words. So they're trying to establish that Lively's the one causing this to happen. She's doing it deliberately to make Baldoni look bad. Again, part of this story is that where Lively tells the New York Times, and the New York Times reports that it is a shadow campaign against her conducted by Baldoni. One of Baldoni's primary responses in lawsuit form is that it's actually a shadow campaign against him done by Lively. That's always going to be difficult to parse out. That's always going to be difficult to sift through for people on the outside of these things. I'd remind folks, we're not in the room. We don't know the perspectives of events on the set. And even now, this is just one party's description of what happened in respect of this filming. And it's not taking Sony's position into account as much as it would seemingly be needed to understand what happened here fully. So we'll continue to get more information as these documents go forward. But right now, it's just two competing narratives looking at the same set of events. Baldoni had no intention of ever making this information, what happened on set, public. In fact, as co-star of the film, both he and his studio, who co-financed the film, had spent millions of dollars, had every reason to want the film to succeed. Any suggestion otherwise is illogical. And again, that's true. This all makes sense unless you were actually sexually harassing Blake Lively on set. And I have already said, as part of this video and video series, that I think Baldoni and his legal team are crafting the more compelling legal narrative here. But you can't ignore the fact that this doesn't get you home if there was actually sexual harassment or perversion, or however you want to describe it, on set, and it was a hostile work environment that she was operating in. Baldoni later received word that during the premiere of his movie Deadpool and Wolverine, Ryan Reynolds, approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, and at a later date demanded that the agent drop Baldoni. This is setting up another portion of this particular case. It's an intentional interference with contract. It is illegal to know that somebody is in a contractual relationship and then to take deliberate steps to harm that contractual relationship. Now, there are a lot of exceptions there. I shortened that substantially so that we could talk about it. There's exceptions for competition. There's exceptions for various other things. But it's illegal to go out there and say, you need to drop this person in this particular capacity. That's what they are trying to establish with this paragraph. His wielding of power and influence became undeniable. Baldoni and Wayfarer grew increasingly fearful of what Lively and Reynolds were capable of, as their actions seemed aimed at destroying Baldoni's career and personal life. This pivotal moment terrified Baldoni and ultimately caused him to seek help anywhere he could to protect his reputation, his partners, and his wife, children, and family from false accusations that could ruin their lives. And again, this is an appeal to emotion, right? His partners, his wife, children, and family. There's nothing wrong with appealing to emotion, but that's what's happening here. Desperate, terrified, and in this position for the first time, he sought expert guidance and was advised to engage crisis PR to be ready in case Reynolds and Lively decided to unleash their wrath on them. As is customary, a proposal was prepared for him with available measures and quotes of what each suggested measure would cost. And this is where I reacted pretty strongly to the original complaint document that Lively put forth, and that was the basis for the New York Times article, is the description of crisis PR and communications control being this evil thing, right? I said in those videos that yes, it can feel icky. It can feel wrong that what these people do is go out there and try to manipulate narratives out in the public sphere, in the media, and otherwise. I don't blame anybody for saying PR grosses me out a little bit, but it is entirely customary. I can back this up for what documents they actually use in that complaint to be put forth to a client, that when you hire this crisis PR team, this is Nathan and Tag, and they say, this is what we can do, these are the kinds of things that we can do, this is what it costs, that in and of itself is not evil. It's certainly not illegal, even if it might feel icky to try to control narratives like that. Unfortunately, these people are in the public sphere, and as we can see in this lawsuit and this entire kind of conflagration, it's important for people in that sphere to try to control the narrative in some respect. This proposal, wrongfully obtained from the very public relations company that once represented Baldoni, and we'll definitely hear more about that in a bit, was later used by Lively to knowingly and falsely assert that Baldoni had agreed to the most aggressive option in the proposal. Lively falsely, and ironically, alleges Baldoni set out on a smear campaign to destroy Lively despite the thousands of documents she alleges to have that would prove otherwise. Notwithstanding, Lively, her team, and the Times, that's the New York Times to you and I, worked in concert to cherry-pick, deliberately misconstrue, splice, and alter private communications to manufacture a self-serving and factually baseless narrative. Now, here we're getting into some of the work that this team has already done with respect to the New York Times lawsuit, right? And sometimes you see this, right? This is the same legal representation. They've already filed this other lawsuit. We can use some of that here. Again, I don't think this claim needs to be 180 pages long, but they're using some of the New York Times case in this particular instance to indicate that this was all a smear campaign and false accusations leveled by Lively against Baldoni. Lots and lots of pictures. We've seen these. We've discussed these earlier in this playlist. Meanwhile, Lively systematically excluded Baldoni from all marketing and promotional efforts with her and the cast for the film. He was not invited to any cast promotional events, cast screenings, premieres, photo shoots, or other cast campaigns. Baldoni was marginalized from the marketing process. The purported marketing plan allegedly created by Sony, which was later referenced in Lively's CRD complaint as agreed to by all and attached as an exhibit as fact, even though it was merely talking points and not a binding contract, was never the plan Baldoni agreed to. And this is an area that I highlighted in this particular document and that we talked about earlier because it does appear to be a talking points document, right? You see it here. It's the log line, positioning, how are we going to deal with questions about whether it's an authentic representation of domestic violence and diversity, et cetera, et cetera. But this is something that people can agree to. It doesn't need to be a signed agreement to say, I am committed to this particular marketing plan. So I think that's probably at least one step too far for the lawyers here to suggest that it has no value as an exhibit. But we do also have the issue with the 30-point email talking points from the January 4th meeting, the issue with describing how the 17-point protection plan that was signed by everybody came to be in the Lively complaint and the Lively lawsuit. So when they say something like, this is going too far for that side, and this is not something that was actually agreed to as a formal marketing plan, then we are more inclined to maybe give them that ground than we otherwise would be, even though this document and what it says probably is sufficient to make the point on its own that Lively and her legal counsel want to make. In fact, against much resistance from the film's distributor, that's Sony, Baldoni from day one made it clear that he was making this film to bring awareness to domestic violence and would not refrain from doing so when promoting the film. He did not go rogue, as Lively alleges. And this is important for her case because she's trying to establish that she only got caught in the marketing situation that did reflect poorly on her because of what Sony and Wayfarer and the overall thrust of marketing the movie agreed to, and that Baldoni skipped out on that. He went rogue and essentially put her in a bad position. Justin says, good morning, team. Now it says Sunday, August 11th. We don't know which August that is. It's probably 2024, but we don't know for sure. So I was thinking about the response to this weekend, and I feel like we should do is make sure to emphasize the voices of the survivors. It's going to be a lot of buzz how much money the movie made, but I want to be the one that always direct that back to the survivors. So I would love to come up with some sort of video or carousel of messages from survivors and the response to the film. This is the same text message that is used by Lively to suggest that he did go rogue and is deliberately moving outside of the marketing plan agreed to. It's used for the opposite purpose here. Again, Rashomon. While in Sweden celebrating his wife's birthday, what a saint, Baldoni was informed that Lively demanded he not attend the film's premiere on August 6, 2024. Lively further threatened that if Baldoni attended the premiere, she and the majority of the cast would boycott. It remained unclear what Lively had communicated to or promised the cast, but they now also refused to attend if Baldoni was present. The fact that Sony advised Wayfarer to concede underscores Lively and Reynolds' immense power and influence. Yes, possibly. But again, we have to at least allow for the ground that Lively may even be irrational, but could truthfully think that she was harassed on set, think that Justin Baldoni is a bad guy, and communicates that to the rest of her cast. We have to allow for that possibility if we're being honest and trying to be as unbiased as possible, looking at these documents only from the sides that have been presented to us so far. Baldoni and Wayfarer refused to succumb to the bullying tactics aimed at excluding them from the premiere of their film, a project they had financed, produced, and owned. This threat marked the culmination of a year-long campaign of intimidation, harassment, and civil extortion. Heath moved mountains to negotiate a scenario that Lively would permit, with the help of Sony, as Lively refused to speak to anyone connected with Wayfarer. Now, one perspective is that this has gotten out of hand from Sony's perspective and is now trying to reunite everybody so that there aren't answering as many problematic media requests as they might otherwise be doing at this point in time. But the other way to look at it is that Sony is essentially still on Team Lively and is trying to make sure that Justin Baldoni doesn't make too much noise on this particular score. Finally, through Sony, Wayfarer persuaded Lively to permit Baldoni and the Wayfarer team, along with their friends and family, to attend, though only under demeaning and humiliating conditions. They were relegated to a separate theater to view the film, required to arrive at a different time than the rest of the cast, and instructed to leave the red carpet immediately once Lively arrived. And I think this is very bad. I think this is a compelling portion of the story, but I also think that it maybe goes a bit too far because describing this as demeaning and humiliating is probably not the same for Hollywood directors, Hollywood stars, as it is for the rest of us, right? The rest of us say, we're going to make this thing, we shouldn't be ostracized in the fashion that we have been as part of this story, but we get to see a movie and we get to go to it with our friends and family. That's probably not the most demeaning and humiliating thing, even if you are in what amounts to the church basement. Baldoni was also excluded from the official celebrity after party, which sucks, right? But it's not the end of the world, despite it being an event ultimately paid for by Sony and Wayfarer, and therein lies the rub. As a result, Baldoni had to quickly organize and fund a separate after-party for himself and the Wayfarer team. I like the use of "had to" there. Yes, I'm not sure you have to actually organize a party, but it's good that you did. And these particular bits of story, I think, are important because they're very, very hard to argue against from the Lively perspective because they have these pictures, they have all of the description of events that this happened in the way that it did. And so I think it's compelling in that fashion, even if I wouldn't describe it specifically as demeaning and humiliating. Once the main theater was deemed clear of Lively and her guests, Baldoni and his group were ushered into a separate theater to view the film. At the conclusion of the screening, they were again quickly escorted out of the building by security to avoid even a chance of interaction with Lively or her guests. The Wayfarer after-party, held separately from the celebrity event and attended by crew, family, and other Wayfarer friends, was a dry gathering. Again, not legally interesting, but potentially trying to make him into a saint, in part to acknowledge the known negative relationship between alcohol and domestic violence. It was attended by the entire Wayfarer team from Los Angeles and their friends and family. The atmosphere and tone of the Wayfarer after-party were aligned with Baldoni's vision for the film, focusing on celebration and gratitude, despite being humiliated. Again, he rose above. He took the high road, right? And again, that's the lawyer's job here. I'm not trying to disparage the writing. I'm just trying to note that when that happens, don't let yourself get emotionally swept away in this kind of stuff. This is the design of this type of writing from the lawyers. I think it's bad. I think the circumstances described are bad. Was he humiliated? Did he reach into himself and find heroic power to somehow rise above in this particular circumstance? I think that might be going maybe a step too far. In the end, empowered by her celebrity firepower and her powerful allies, Lively did exactly what she set out to do. She took someone else's movie for her own, destroying years of creative vision and careful planning in service of her own brand-building campaign. But why would Lively even seek to seize power over the film? Why would she insist on taking on additional work for no additional pay or credit? Now, this paragraph I highlighted specifically because this is not what you usually see in a legal document. We talked about it already being a long legal document for this purpose, but you don't usually have to ask why in this context. You might have to prove motivation later on if you've got competing evidence and you want to make it clear to a jury or a judge in a bench trial. But this is an aside as a result of this being a PR war. What, right? Somebody looks at this and says, okay, but it seems to me more likely that someone might take advantage of their position of power over another for sexual or other purposes. And the story she tells is at least reasonable. We can understand what's in that complaint document, both in the federal case and in the California complaint. So why in the world would she do this? And then you offer up a solution, not so much for the court to care about, not so much for the lawyers to respond to, but for us here in Hangouts and Headlines, for the Hollywood Reporter and others to discuss. Why would she do this? On information and belief, meaning we don't know, but we think maybe this, Lively may have been motivated by a number of factors. Now, this is a weird sentence because you don't have to say on information and belief, Lively may have been motivated by a number of factors. That's every human action ever. Everything that's ever been done or not done on this planet Earth has been motivated by a number of factors. You don't have to give information and belief to that. She may have wanted to seize control over the film so that she could take over the production of its sequel. It Starts With Us. Is the sequel of this really called It Starts With Us? Fair enough. I hope you enjoy your books. This motivation also explains why the cast, who may have hoped and or been promised a role in subsequent productions, would choose to side with the powerful couple who themselves may genuinely believe they could destroy Baldoni and Wayfarer and force them to cede, or even sell, I think it's probably sell or even cede, the rights to the sequel. So, we don't really know. On information and belief, Lively is a bad person, and you should remember that, Judge. So we're going to just throw some stuff out there. This paragraph is entirely speculative, as best I can tell. But maybe she wanted to make the sequel, and she used that to bludgeon her castmates into boycotting our saintly Justin Baldoni. And for folks that are new to Hangouts and Headlines or virtual legality overall, I get this comment a lot. But when we read documents, the best way to read them is to kind of read critically and to play this kind of devil's advocate position so that we don't fall into critical thinking traps as we go through. It can sound like I'm taking the entire opposite position of an advocacy piece like a complaint document like this one. You can go back in this very series and see me doing the same thing with Lively's documents. And I had people accuse me of essentially deciding to be on Team Baldoni to start out with. So I hope that doesn't rub you the wrong way, but is the way I look at these things. I think it's useful as a practice to go through these documents in this way. I am not trying to just destroy Baldoni's arguments here in favor of Lively's. I'm just pointing out when I think maybe they go too far or when there's rhetoric or appeals to emotion that maybe we should not take at full face. Or let's offer some more speculation. Lively may have felt driven to match her star husband Ryan Reynolds, who is widely reported to have insisted on taking so much control over the film Deadpool 2 that the director, Tim Miller, left the production. Seeing the fame and success that Reynolds commanded, she may have adopted his oft-repeated pattern wholesale to seize her own power and control. Following his lead, and evidenced by many statements by Lively that he is involved in every project she works on and vice versa, Lively and Reynolds, accustomed to getting their way, perhaps felt entitled. So maybe they're trying to steal the sequel rights that we've otherwise negotiated with Colleen Hoover. Maybe they're just entitled Hollywood assholes, right? Like maybe that's what's happening here, Your Honor. And we don't really know. I mean, one other paragraph you could add with just the same fact pattern is maybe she's jealous of her husband. But that doesn't get included here. Regardless of why Lively insisted on seizing control of the film, that is precisely what she did. There can be no justification for her Machiavellian and civilly extortionate tactics. They keep putting civilly there because that's as opposed to criminal extortion. We'll get there in a minute. Deployed to grab complete control over the film. Lively also sought ultimate control over the film in the hope of boosting her own brand and business ventures. In the end, though, Lively's own words and promotional strategy led to the avalanche of negative press. Now we're going to essentially answer the complaints that says that we were engaged in a retaliation campaign against her so that she would keep quiet about sexual harassment. Starting in at least July 10th, 2024, Lively's social media posts promoting the film maintained a lighthearted, frothy attitude depicting Lively in glamorous and floral-inspired couture, highlighting high-end brands like Chanel and Christian Louboutin. I'm sure I got one or more of those words mispronounced, so I apologize. Then we got a bunch of pictures of Instagram photos of things in flowers. Grab your friends, dress your florals, whatever it might be. I can't remember the phrase entirely. Lively freely interspersed posts about her new movie with ads for her new hair care line, Blake Brown. We saw that described earlier. And also sprinkled in cross promotions with her alcohol brand, Betty Booze. Apparently, she really likes the letter B. This was a massive error in judgment, says the lawsuit. Social media commenters quickly pointed out that this tie-in was in particularly poor taste, given that the World Health Organization estimates that 55% of domestic violence incidents are linked to alcohol. We've heard this discussed at length. Tellingly, Wayfarer spotted the issues and called for a course correction long before Lively apparently realized the magnitude of her miscalculation. Wayfarer CEO Heath responded to the organic online criticism. Again, it's important that the criticism of Blake Lively is described as organic because what's being accused of the team at Wayfarer by Blake Lively and her team is that they created an inorganic AstroTurf fake campaign to harm her in order to keep her from going public with the sexual harassment claims that she has made against Baldoni and Wayfarer. By noting that many people are pointing out that domestic violence is being glossed over and that Justin is essentially the only one appreciating the subject matter, whilst others may be not giving it the proper respect it deserves. As you know, this has always been a concern of ours, and if we were to scroll back to the marketing points that were loudly said to be not something that was agreed to by everybody, but were talking points for everyone, one of those questions was, what happens when people ask us whether or not we're treating domestic violence properly? And having a response in place is suggestive of the marketing team, is suggestive of Wayfarer and Heath and this description of events being accurate. We knew when we were making this movie, we knew when we were casting it in the way that we were, that some folks might look at this and say, we are not treating domestic violence with the respect and seriousness that it deserves. So we better be prepared for that. And so this all checks out to me. It passes the sniff test that what is happening is Wayfarer and Baldoni and Heath are not happy with going out with such a lighthearted, frothy marketing campaign and are not happy, certainly, with Blake Lively marketing her hair care and alcohol products along with it. With that said, I think it's about time for me to take that much promised break for my voice and to check in on you all and see what kind of comments you have. So before we get into the current comments, I did want to make a highlight note of the member comments. Joe Beer, thank you for being a member here for 2 years. 2 years, whoop, heart emoji. Thanks for doing these, Hoeg. Love the completely non-biased view you have on this. As I have said, I have a certain amount of tilt against Ryan Reynolds. So I'm not sure I'm completely unbiased, but I do try to make those tilts when I notice them obvious to all so that you can judge that transparency on your own. Also, I kind of miss the orange wall. Smiling, laughing emoji. I get that. Yeah, we have a new backdrop for the last year or so. It just made a better configuration for my office after coming back from the hospital. So I appreciate it, and I appreciate the support, Joe. Thank you for being here for 2 years. And Sandy, always here, always gifting Hoeg Law memberships. Thank you so much for gifting those. As I mentioned in the last video that we did in this series, I am trying to add value to the memberships here on the channel. So if you are interested in supporting the channel, you don't want to do a super chat, you don't want to do a direct contribution on Patreon or otherwise, I do appreciate those gift memberships. And if you are in the chat right now, you'll want to make sure that your buttons are properly pressed on YouTube to accept gift memberships when you're in a chat, when you're viewing something live, because YouTube wants to make sure that you are accepting of those. You don't want to just be made a member of something that you don't want to be a part of or publicly known as. I don't really think that's a big deal mostly, but YouTube does have buttons you need to check to get gift memberships. So please do that. And Sandy, thank you so much for gifting them here. I really, really appreciate it. Now, let's see if we can grab any other comments, chat. Let me dig into the chat messages here and see what else y'all are talking about. Looking for Hoeg is absolutely wrong. Hoeg is dumb. Let's see what we got here. SJ says, Lively never signed her employment contract. They kept asking her to, but she never signed. Will that impact the case? Well, that's what I flagged as that one sentence in the paragraph. I've heard that discussed in various other places in whisper form. It's not a prominent part of the lawsuit. I don't know why that is, but it is referenced at least once. It depends on what they were looking to have her sign. There are different aspects of this. We see reference to the fact that she has her own, I think it's an LLC, where she essentially loans out her own services as part of being the only employee of her solely owned LLC. So it could depend on what was looked for there. It depends on whether they had any promotional commitments by contract that she was otherwise just deliberately breaching in order to get something else. That can be extortion in certain contexts. It depends on a whole host of things, but it could impact the case, absolutely. Lucy Furious says his name wasn't uncredited as a director, just taken off the poster. Yes, you probably didn't negotiate for poster rights, but we do see those from time to time as well. My name will be on the leftmost side. My name will be biggest. No other name will be bigger than mine. I will get a film by credit. It will be X amount of font. These marketing things matter significantly in areas of media creation, certainly in Hollywood and movie creation. So it still could be a contractual issue, even if it's just the poster. Thank you for bringing it to my attention, though. I really do appreciate the extra context. Catherine, thank you so much for being a member for 15 months and for your membership chat here. Happy to have here reasonable discourse and to gain legal knowledge. Thanks for this heart emoji. I certainly hope we can have that reasonable discourse. I absolutely love checking in on the chat and the comments because so many of you are using your reasonable minds can differ philosophy, using your critical thinking skills to have good conversations, even when you disagree. And I will tell you, folks, that being online, being on social media these past couple of weeks, looking at this issue, things have gotten much more passionate. Things have kind of tribalized. People have gotten on Team Baldoni. People have gotten on Team Lively. I don't see it becoming less passionate, folks being less emotional about these arguments in the future. So if we can provide good information, if we can provide good education here, I would ask people to continue to tell folks that we're having these conversations here, even if this is the last one on this particular topic, because it is so important to me to try to have Reasonable Minds Can Differ be more of the guiding philosophy for more folks out there on the internet and just in their lives, because we are all human beings. People can look at the same set of facts as we are seeing in these legal documents and come to different conclusions, and understanding that that doesn't make them less of a human being is so, so important to me, and I hope that it's so, so important to you. So thank you so much for supporting the channel, Catherine, and everyone else here in the chat. Abigail says, you're doing great, Hoeg. Has it only been a year or is it 2 now since the stroke? We passed the 2nd anniversary in December, but I think 2025 is really the first time where I've been able to kind of focus on rebuilding the firm, rebuilding the channel in a way that I think can be sustained and can move forward. I want folks to know that I am constantly working on that. I've talked about the fact that I've eliminated one of my support platforms because I just wasn't able to look at both platforms at the same time. And I really appreciate everybody supporting me in doing that, even though I haven't been able to meet those pledge obligations, those tier obligations like names and sponsorships as much as I've wanted to over the past 2 years. But I fully intend to have a regular cadence of content here on the channel in Hangouts and Virtual Legalities. You would have seen a Virtual Legality go live to the public this morning after it was made available to members first on Monday. I've done that for a couple of weeks in a row now. And I fully intend to also start collaborating more with some of the folks that you might recognize on YouTube, some of the Lawyers and Dragons crew, sooner rather than later, and have more conversations with more people so you don't have to just be left with my voice all the time. Thank you so much for the support. Abigail says, I wish you would cover politics too, because it'd be great to have someone break down the language people use when reporting on political things, but I can understand how it can feel much more risky. Honestly, coming right out of the hospital, Abigail, one of the things that really did feel problematic was making sure that I could extemporaneously speak and not lead people astray and not create more outrage, more fire on the internet. And that was something that was holding me back from content creation for a good chunk of last year. I still don't like getting too deep into politics because those passions are so high. And people are so strongly positioned on one side or the other. But I do think there is value there. And I can tell you personally, don't tell anybody else, this is just between you and me, Abigail, that one of the shows I am currently concepting out would be a short format that could take occasionally political stances that hopefully would help inform people and lead to greater understanding on the internet. That is well away from being a reality right now, and it would require a completely different format and structure for creation. But it is something I am actively thinking about, and I want you to know that I do see all of the fire and some of the misreporting and other things out there right now on some of the big issues facing people today. And I don't want to get too deep into the culture wars. I don't want to get too deep on the political side. I really don't want this to be a space where people feel like they can't be heard because of political leanings that they have one way or the other. But I do think that there is a useful place for me, and I'm trying to figure out where that might be. So thank you again, Abigail. Thank you, everyone, for supporting the channel. I hope you're having good conversations in the chat. I love to scan through. You guys probably don't know this, but after the video is ended, I go through the chat in its entirety to see what you guys were talking about and try to figure out what I was saying at the same time that you were talking about them. And I've been so, so grateful to see so many well-positioned, well thought out, rational takes, even when I can see 2 or more people are in massive disagreement on one or more aspects of what I'm saying. I love that so, so much, and you guys are the reason that I do this at this point, because I love having a corner of the internet, even if it's a tiny one, even if it's just this little minuscule portion of discourse that looks at this and says, you know what, you disagree with me, but you're a human being, and I can respect that a different person can look at the same things that I'm looking at and come to a different conclusion than I am, even if I don't try to convince you adamantly to look at things the other way. Melly Bobelli, let's see if I can pronounce that right. As someone who hates rhetoric, I look forward to a critical reading Reasonable Minds conversation on political reporting and or government documents. We will see. I can certainly appreciate that. I appreciate having this as part of the conversation here, because it is something I want to do. It is certainly something that I have seen fly around, and I do think that I can offer some value. And if I can get that format working, you will see a new show on this channel. I want to support the people that do so much to support me. And if that's useful to you, and I can do that, and I can make that, that's something I want to do. All right, folks. Well, again, my break times aren't so great at being break times. I'll figure this out so I can do 3-hour straight videos a little bit more. But we'll get into the letter here. This is from Jamie Heath. It says, so we see all the noise and chatter regarding Justin and Blake and cast. This is all crazy. But I'd like for us to take a look at that even in the midst of quote-unquote feuding, how many people are pointing out that the domestic violence is being glossed over and that Justin is essentially the only one appreciating the subject matter. As you know, this has always been a concern of ours, and as I said, the marketing plan suggests that that is true, and I think we might agree that there is enough response to at least considering giving it a bit more thought. We are opening with great numbers, and that is a testament to the movie itself and also the way you've positioned it, no doubt. And we should listen to the responses and really embrace what we are hearing. It won't hurt the movie by being more deliberate in embracing the domestic violence aspect. People need to know that we too recognize the gravity and sensitivities of this subject. Looking forward to your thoughts, Jamie. So I think that's useful to once again indicate that they are interested in this particular topic. This is Jamie Heath to Sony, but I don't think that this message actually says too terribly much at the end of the day. Wayfarer's Vice President of Marketing and Communications shared a post exemplifying the issue, which included the tagline, "Grab your friends, wear your florals," there it is, that soon became viral for all the wrong reasons. And she used it on, I think this is Instagram. Pardon me for not knowing all the formats, the various social media chains. Heath and others at Wayfarer advised listening and responding to the wave of online criticism that had met the bubbly, sunny messaging that Lively herself embraced so wholeheartedly. Though Lively now claims that Heath, Baldoni, and others at Wayfarer sabotaged her by planting AstroTurf media criticisms of Lively, it seems that if she had listened to and respected plaintiff's perspective and insights on the unique sensitivities of marketing the film, rather than seizing the helm and then driving the ship aground, everything would still be coming up roses for her. Again, this is a lot of extra language for a legal document, but again, they're trying to craft a story. They've already put in your head that maybe she did this because she's entitled. Then you say, okay, we're going to keep leaning into that entitlement and say, all you had to do was listen to us. We identified this early on. Lively's reputational backlash was entirely her own doing. To be clear, we are not saying it's been inappropriately marketed in any way. So we're clear, Sony. We're not angry at you. You guys are great. Thank you for being awesome, international motion picture makers. In fact, you all have been brilliant. Thank you. Extremely honored to be partners with you. It's been fantastic. The proof is in the pudding. This post is only pointing to the ones who have spoken about the marketing, and while I am not dissuaded by their commentary, it's good to take some learnings from it. I know and trust you understand the point, and I look forward to discussing it with you all. Congratulations on a huge, huge success. You play a big and amazing part in it. So we talked about the obsequiousness down, right? We talked about Justin Baldoni talking to his actors and actresses with that kind of ingratiating format and that being maybe a little much for us on the outside of the Hollywood bubble to look at. Here you see it going up, right? Here you see the CEO of Wayfarer trying to ingratiate himself to Sony, and this is that same kind of communication. I will tell you from practical experience that this is good, this is useful for kind of social lubricant in certain respects. It does tend to prevent real answers from happening, real actions from being taken to solve real problems, because everybody's too kind of taken up with patting each other on the back and telling everybody that they're doing an awesome job to actually get to the heart of what the issue might be, which might be entitlement, might be sexual harassment, might be something else entirely. And I do think that's probably a problem, a dysfunctional relationship with Wayfarer, Sony, and Baldoni and Lively and Reynolds and everyone else. But once the backlash started on social media, without any effort by Lively to course correct and entirely without any involvement or effort by Baldoni, this was not our smear campaign, Your Honor, it rapidly spread to mainstream media. And then they have what we would call a chain citation. This is so many things. Look at all these articles, right? Which is interesting to include here because the accusation against them is that they fostered a smear campaign. This sure looks like a campaign, right? This is a ton of articles. You've claimed that it was all organic, but someone could get into these articles and say, this was organic? Really? This looks like a leak to me. And so this is at least a bold step to include a citation like this, but you're trying to establish that she did it to herself. Embarrassed and enraged by the self-induced backlash, Lively now seeks to vilify Baldoni in a dubious attempt to resuscitate her public image. Upon information and belief, Lively ordered her team to begin a campaign to frame herself as a martyr and pin the blame on plaintiffs. So the story so far is that She took over aspects of the film, both early on, during the Writers and Screen Actors Guild strikes, and then after the fact with respect to marketing, editing, and otherwise creating the movie. And then she found herself in trouble because of this long set of articles that are coming out and hurting her Q score, hurting her brand recognition, hurting how people feel about her as a person, and said, we are going to have to do something about this. And so behind the scenes, says this lawsuit, Lively's publicist, Leslie Sloan, devised and executed a smear campaign of her own against Baldoni. Known for her tendency to leak sensitive stories to provoke public controversy, Sloan reneged on an agreement with Nathan by continuing to disseminate false and defamatory stories about Baldoni and Wayfarer, a process she had begun long before Wayfarer and Baldoni ever retained Nathan. So Leslie Sloan is Lively's publicist. You see that described here. And then I think this is a fairly weak claim, but the claim in this particular section is that Sloan reneged on an agreement with Nathan, Melissa Nathan, who is their crisis communications specialist, to stop disseminating stories to these various media outlets. And the actual agreement is as follows. At 10:11 a.m. Pacific Standard Time, on August 8th, 2024, Nathan and Sloan reached an agreement whereby neither would communicate directly with a reporter prior to informing the other. Nathan states, this is the entirety of the agreement, folks. Nathan states, I am not doing one thing without speaking to you. To which Sloan responded, me either. That's the entire crux of what will be multiple paragraphs on this, is that Melissa Nathan, on behalf of Wayfarer, says, I'm not going to do anything without speaking to you so that we can coordinate whatever kind of narrative we want to put out there. And Leslie Sloan, on behalf of Lively, says, me either. And that's the agreement. This is what was reneged on. This is how we were taken advantage of, Your Honor. Just 9 minutes later, Sloan breached her agreement with Nathan by engaging with a reporter at the Daily Mail. The reporter asked to speak with Sloan regarding problems on the set involving Blake Lively and Justin Baldoni, and the fallout over that with Blake being labeled difficult and a power struggle existing. Sloan, without consulting Nathan, it's unclear to me exactly how consulting would look in this context, another text exchange, I suppose, promptly responded, that is 1,000% untrue, and further, your info is totally off. It is evident that Sloan never intended to honor her agreement with Nathan. Instead, she exploited the arrangement to gain a strategic advantage in the media. So this is then the pictures of that particular exchange. Your info is totally off. Again, I look at this and say, all right, you said you're not going to do anything, meaning you're not going to place articles, you're not going to otherwise start anything. Someone reaches out to you and you say that's wrong, but I'm not going to otherwise say anything else. Maybe it doesn't rise to the level of a massive agreement breach. In fact, Sloan actively continued her discussions with the Daily Mail reporter, seeding false information to cast Baldoni in a negative light. To divert attention from Lively's tyrannical behavior on set, Sloan attempted to portray Baldoni as the antagonist, stating, the whole cast doesn't like Justin. Nothing to do with Blake. She doubled down, insisting, I'm telling you, she's a liar. They are panicking as the whole cast hates him. Sloan also threatened the reporter, saying the entire case I will have go on the record. This needs to hold. So she's trying to get this story held that would suggest that Blake Lively is at least part of the problem. And that, to me, again, doesn't rise to the level of this is a nefarious bad actor. I think this is an overreach by the Baldoni legal team on this particular score. Why are they overreaching? Well, we'll get to that in just a minute. At 7:59 a.m. Pacific Standard Time on August 9th, 2024, Nathan, consistent with the pair's agreement, sent a text message to Sloan containing an email she had received from a Daily Mail reporter. Unbeknownst to Nathan, this was the same reporter with whom Sloan had been communicating the day prior. Nathan confirmed that she played no part in the story and told Sloan, I'm going to have to speak with him, but I'm just going to tell him nothing. And again, I'm not positive that Sloan really said much of anything there except that it's not Lively's fault. And so that's not nothing, I suppose, but it's not a lot either. Sloan deliberately omitted the fact that she had spoken with the reporter just 24 hours prior, stating, let me know how it goes. Despite their agreement, Nathan was completely unaware that Sloan had provided the reporter with information that significantly altered the narrative of the published story. Indeed, the reporter originally sought to publish a story about Blake being labeled difficult on set. It certainly sounded that way. After the reporter's discussion with Sloan, however, the story changed to, we have learned that Justin Baldoni caused issues on the set. Not only did Sloan breach her agreement with Nathan, but she planted false and defamatory information about Baldoni to distract from Lively's numerous missteps and throw Wayfarer and Baldoni on the defensive. And again, if that's your best case, if that's your biggest arrow in your quiver, I think you maybe don't have much of a quiver on this particular point. Following the release of Lively's administrative complaint on December 20th, 2024, that's the article that brought all of us together, folks. The same Daily Mail reporter informed Nathan that Sloan had lied to portray Baldoni as the foe. Yet still, Sloan escalated the false narrative by telling the reporter that Blake was sexually assaulted, an unsubstantiated accusation that not even Lively had gone so far as to claim, designed to destroy Baldoni and his reputation. Indeed, one of the things that is noteworthy about this particular case is you don't have that assault feature, right? And that can cause a problem for women or others that are claiming a sexual harassment or hostile workplace case, because you don't have that smoking gun, you don't have that silver bullet. You don't need it necessarily to make your case, but it is easier if you have that. So when you accelerate things to saying there was an assault, that can be a problem, certainly. Sloan ruthlessly took advantage of Nathan's good faith. As a result, Nathan was forced to combat the negative press that was both planted and propagated by Sloan. Ultimately, the actual smear campaign was orchestrated by Sloan at Lively's direction. And then we get Stephanie Jones. We're going to get to Stephanie Jones. We are. This is a long piece of this document. I think it's way longer than it needs to be because Stephanie Jones is not directly a part of this action made by Baldoni and Wayfarer against Lively and her team. But this is a long piece of discussion material. And I know folks that are in this chat have probably come to their own conclusions about Stephanie Jones, about the lawsuit that is engaged with between Stephanie Jones and Jennifer Abel, and various other aspects of this that we haven't discussed at length in this space. But I wanted to point out that this is necessary, or at least thought to be necessary, for Baldoni's team to establish where all those text messages come from in the California complaint and in the federal lawsuit filed in New York. The claim in the New York Times article was the complaint and us at the New York Times have been made privy to all of these documents by virtue of a response to a subpoena. What does that subpoena mean? I pointed out when we read that article, it was entirely unclear from the New York Times reporting. It has something to do with Jones v. Abel and being able to go and ask for this information from Jones, or at least as claimed by Baldoni and his team. Enter Stephanie Jones, Wayfarer's and Baldoni's embattled former publicist and a critical player in Lively's scorched earth campaign against Baldoni. Jones is the founder and CEO of JonesWorks, a New York-based public relations firm that Wayfarer engaged in May 2020 and that later handled publicity for Baldoni personally. For almost 4 years, the JonesWorks Baldoni Wayfarer account was managed by Jennifer Abel, Jones's right hand, who ran the JonesWorks Los Angeles office. Abel developed a close and trusting relationship with Baldoni, Heath, and the rest of the Wayfarer team, particularly as their strategic communications needs became ever more complex due to defendants' machinations. Not just plans, not just actions, they're machinations. You know that means defendant did something really bad, Your Honor. In any event, this particular relationship is described in this document of signing on to a firm for any professional service and getting closer to the actual person that's rendering that service is not an unusual one, right? It's one of the reasons why when we get a little bit later on in this story, you'll see why a firm has such strong kind of requirements for signing on to documentation as you are terminated or otherwise resign your position with them, why you have to turn over your laptop access and phone access and things like that, is because the clients themselves get a personal relationship with the person that's actually rendering them services. That makes all the sense in the world. They didn't actually have a relationship with the entity. They had a relationship with the human beings that did things for them, in this case, Jen Abel. And so there is that closeness. Oftentimes, contracts will have a non-solicitation provision in which professionals that offer those services agree not to otherwise take clients with them when they leave the employ of that company so that they don't steal trade secrets or other things as part of a new relationship with a new client. That doesn't happen here, probably because non-competition provisions overall are held to be void in California, and this takes place in California. But otherwise, you'd see in professional contexts other rules that often prevent clients from moving on with people that are leaving. In this case, that doesn't happen. Long known within the public relations industry for her disarming Southern twang, brass knuckle tactics, and high turnover of clients and employees, Jones has had a successful career, having founded JonesWorks and represented at various times Dwayne "The Rock" Johnson, Jeff Bezos, Lauren Sanchez, Venus Williams, Tom Brady, and Chris Hemsworth. That is a pretty good collection of high-profile clients, I have to say. But I also like this little bit of language here. Very much a novel kind of thing. You could imagine it being in a book like It Ends With Us, right? You describe the person with a disarming Southern twang, brass knuckle tactics, high turnover. Until recently, however, Jones had kept her worst excesses hidden from public view. That changed in or around May 2024 when Puck reported that Sanchez and Johnson had dropped Jones as their publicist. I have to admit, I don't know Lauren Sanchez from Adam. While these were among the most prominent and publicly reported departures, a cascade of JonesWorks clients began to cut ties with Jones, especially after word had spread that Business Insider was contacting Jones's former and current clients and employees concerning a forthcoming article about her sordid behavior. On May 8th, 2024, a website called Stephanie Jones Leaks went live, along with an X.com account, a Facebook page, a Reddit account, and a Pinterest page. These platforms disclosed a litany of highly disturbing allegations about Jones's behavior and business practices. These revelations caused a firestorm in Hollywood, resulting in a surge of negative publicity regarding Jones. The Business Insider piece shed more light. Always a volatile personality, Jones had become noticeably more paranoid, erratic, and cruel in recent years. The Business Insider stories shed light on the toxic workplace Jones had fostered at JonesWorks. At the office, Jones would regularly turn on deafening music so that she could berate her employees free from scrutiny. "I don't think there was one day in the office that someone wasn't crying," said a former employee. Again, not a great place to work by the sounds of things. Of course, having worked in big law firms, there can be crying, there can be emotionality, there can be a lot of getting yelled at. Jones also pried into her employees' private lives without invitation. When employees called in sick, Jones would FaceTime them to confirm that they were actually sick. Again, I think that's only one notch above calling them to make sure they're actually sick, and I've certainly had that happen in the past. In at least one instance, an employee who had taken a personal day to attend a funeral received a FaceTime call from Jones during the ceremony. Jones was apparently suspicious of his whereabouts. Presumably he had said he was going to a funeral. And that's paranoid, that's weird, that's not necessarily who you'd want as your boss, but here we are. Unsurprisingly, turnover rates at JonesWorks were extraordinary. She churns through people. These departures included not only junior employees who often left after less than a year, but also senior executives who managed client accounts. Jones seldom allowed them to go amicably, often enlisting attorneys to threaten and intimidate them into agreeing not to disparage Jones. I love it when attorneys have to write about other attorneys, right? Because suddenly, in the labor context, it becomes attorneys that are threatening and intimidating. We're, of course, awesome. We're only writing 180 pages of legal documentation here out of the goodness of our hearts. We're just doing this to defend our saintly client. But in this particular context, Jones signs up these attorneys to be intimidating brutes. They're just mobsters, Your Honor. Through it all, Jennifer Abel remained loyal to Jones, sticking with her through thick and thin despite growing doubts about Jones's ability to function professionally. Jones had become increasingly hostile towards Abel, criticizing Abel's management, displaying paranoia about her close relationships with clients and partners, and going out of her way to reprimand, demean, and embarrass Abel in front of junior employees she oversaw. Over time, Abel became convinced that Jones was in a downward spiral and harbored serious concerns about Jones's mental health. Jones had become increasingly erratic, calling and FaceTiming Abel at all hours of the night in a frenzied state, overtly pitting employees against each other and attempting to catch them in perceived acts of disloyalty. It does sound like a legitimate kind of paranoid episode, at least as described in this document, and certainly people can have mental illnesses befall them. Jones had always been volatile, but her behavior had become downright deranged. Often, Abel was on the receiving end of her outbursts. For instance, Jones informed Abel's charges that she had learned through psychic readings that Abel was an alcoholic and a gambling addict. Neither has any basis in fact. Well, I took that from your inclusion of the psychic readings as the evidence to that, but I appreciate the clarity. Already pushed to the brink, Abel finally had enough when Jones demanded she corroborate falsified accusations against a senior JonesWorks employee in an effort to drive him out. And so the story here, and again, this is a part of storytelling, it's one side of a particular document, is that Jen Abel, like our saintly client, Justin Baldoni, also could not abide by being asked to commit fraud, and so she left. On July 10th, 2024, Abel notified Jones of her departure from JonesWorks and intention to start her own business. Predictably, Jones took the news poorly. With several weeks left in her tenure and innumerable client matters to handle, Abel found that she had been removed from client email distribution lists and left in the dark about meetings, calls, and events she was expected to attend. It was clear to Abel that Jones was trying to embarrass Abel and tarnish her professional reputation in advance of her departure. And again, we got the psychic readings, we got the paranoia. It does seem to be a downward mental spiral, but just on its face alone, not being allowed to do certain client calls, not being allowed to be on certain emails and distribution lists after you've already tendered your resignation and we're in the last days of your relationship with the entity, not that unusual. A lawyer, in a lot of respects, would advise to try to cut ties and eliminate access points for someone to potentially do damage to you, right? In a different world, in a different universe, the concern is that Jen Abel or whoever else is leaving your employ can do major damage with your email list, can do major damage with access to your systems if you don't otherwise control for that access in their last couple of days. In her final week, Abel contacted Jones's chief and staff concerning the release of her phone number. When Abel joined JonesWorks in 2020, she ported her existing phone number, which she had used since high school, and switched to a JonesWorks-issued iPhone. Now, this should be self-evident to a lot of you why you don't want to do this. You don't want to port your existing access points over to a company-issued phone, but it will become even more evident as we proceed through these paragraphs. Knowing that she would have to turn over the physical device upon her departure, Abel arranged for her phone number to be released so that she could port it to a new device. JonesWorks' chief of staff assured her multiple times in writing that JonesWorks would cooperate and uphold their agreement. They don't have a right to her phone number, they just have a right to her phone. On August 21st, 2024, 2 days before her last day, Abel pulled up to the JonesWorks office in Beverly Hills. There, she was confronted by a physically imposing security guard, a lawyer sitting at a conference table covered in documents. I mean, heaven forfend, right? If you walk into a room and you see a lawyer sitting at a conference table covered in documents, you walk out of that room. An IT professional and Jones's chief of staff who had flown in unannounced from New York. Apart from Jones's chief of staff, Abel had never seen any of them before. After being ushered into the conference room, Abel saw that the security guard was posted just outside its doors, blocking the exit. There, the attorney pointed to the documents and told Abel, in a menacing and cold tone, as attorneys are wont to do, to review and sign them. Please look at and sign those documents. The attorney told her that JonesWorks believed she had proprietary information on her personal laptop and would likely have grounds to sue if Abel did not allow them access. And again, I want to say from personal experience that leaving a professional organization is not the least stressful thing that you can possibly do. I left a big law firm, so I definitely had those lawyers in rooms and looked at documents and did various things to exit from that particular relationship. I can tell you it's uncomfortable. I can tell you it's very stress-inducing. I don't know that there was an attorney pointing to documents in a menacing and cold tone. I'm not sure that that's exactly what the attorney did, but it is off-putting. Completely caught off guard by this hostile and intimidating display, Abel fell into a state of shock. And here's where I start to disbelieve some of this storytelling, because again, we just heard that Jen Abel was one of the sole survivors from Stephanie Jones's increasingly erratic, paranoid, downward mental spiral. And yet, faced with an attorney at a conference table saying, sign those, she became fearful that she would burst into tears and humiliate herself, which she knew was what Jones wanted, and Abel disassociated. Knowing that she had not done anything wrong and desperate to get out of there, Abel signed the documents without digesting their contents. Now, we're not going to hear about these documents much more, but this is important. Why are you not telling us what those contents said? Because we can read between the lines that there must have been something in there that changes some of the state of play, because you're trying to establish that she didn't read them when she signed them, so there wasn't a meeting of the minds, it wasn't a true contract. But you don't tell us why that would be a concern of ours. And that's probably within Jones v. Abel, so I apologize for not having that substantively in the back pocket here. But we don't know, but we can point out when the lawyers are maybe hiding the ball a little bit. The attorney then instructed Abel to hand over her phone, after which security would escort her out of the building. Still utterly shell-shocked and desperate to get out of there, Abel agreed to hand over her phone so long as that would confirm with JonesWorks would immediately replace... let me try reading that sentence in English, folks. Still utterly shell-shocked and desperate to get out of there, Abel agreed to hand over her phone so long as they would confirm that JonesWorks would immediately release her personal cell phone number, which would enable JonesWorks to take possession of the physical device without gaining unrestrained access to its contents. It would also allow Abel to get a new phone and move on with her life without undue disruption. Abel went straight to a Verizon store a short distance away. The JonesWorks chief of staff assured Abel and Verizon that they were in the process of effectuating the release and to bear with them for a few minutes. Abel never heard from him again. After 4 hours of desperate, unanswered calls, Abel left Verizon in panic and despair. Abel realized Jones had double-crossed her in a very serious way. By refusing to release Abel's phone number, JonesWorks had usurped her contact information and cut off Abel's access to critical accounts protected by two-factor authentication linked to that phone number. As a result, Abel lost access to her iCloud, including all her text messages, photos, and contacts, bank accounts, utilities, insurance, and virtually every other sensitive account. By contrast, Jones now had unrestricted access to everything stored on Abel's phone, her text messages, emails, personal photos. Jones could read her communications with her fiancé, parents, friends, everyone. Jones was acting purely out of spite. Maybe. Certainly the story you have told us suggests spite, suggests revenge, those kinds of things. But it is also possible that she took possession of the phone, took possession of the laptop, had her sign the attorney's documents, the things that would be needed to actually exit the employment, And Jen Abel was taken aback by how this process actually looks in real life and made some mistakes in what she signed and what she did. It took Abel over a month to regain control over all her accounts. Meanwhile, she learned that Jones had been sharing her private text messages with the entire office, mocking and disparaging her. Certainly for a public relations professional, one of the things that you've undoubtedly signed as part of your relationship forms with your clients is a non-disclosure agreement, is a confidentiality provision that says I'm not going to disclose these things in a way that paints you in a bad light or otherwise for third parties in their own viewing. This looks like something that Jen Abel wound up doing as described, innocently enough, but allows these kinds of things to get out to the New York Times in a roundabout way. Having torched Abel's privacy and dignity, Jones started boasting that Abel's business was next. In or around early September 2024, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. Then Stephanie Jones has a falling out with Wayfarer and Baldoni. By then, Jones also had an axe to grind with Wayfarer. For the entirety of Wayfarer's 4-year engagement with JonesWorks, Abel was the point person on the account. Jones was more concerned with prestige clients like Tom Brady and devoted little to Wayfarer or Baldoni. But JonesWorks was in utter turmoil by mid-2024. At the time, Wayfarer and Baldoni were in the midst of a massive PR crisis themselves, as news stories began to trickle out concerning tension between Lively and Baldoni just as the film was about to premiere. This isn't that long ago, folks. You might remember some of this happening on social media and otherwise in the summer of last year. Abel recommended that Wayfarer engage a crisis PR specialist, Melissa Nathan, to assist in navigating these choppy waters. The need for crisis PR expertise was particularly acute due to Lively's demand that Baldoni not be permitted to attend the premiere. In addition, Abel learned from Nathan that per her media contacts, a negative story was being shopped around to multiple outlets, positioning Baldoni's religion as a cult and accusing Baldoni of having fat-shamed Lively. Interestingly, that religion as a cult concept doesn't appear in the complaint documents. There's not an obvious way to make that into a sexual harassment complaint, admittedly. But if that was being shopped around, certainly the fat-shaming concept would have been recognizable to Justin Baldoni and Jamie Heath, whether it happened in the way that it was described or not. They knew that Lively and Reynolds had threatened that accusation. When Jones learned that Wayfarer was considering retaining Nathan, she was furious. Jones viewed Nathan as a competitor and conveyed to Abel that her recommendation to Wayfarer was a betrayal of trust. And again, this does, at least in this picture painted, suggest paranoia, suggest these kinds of diminishing mental spiral elements. And so she looks at hiring a crisis competitor as a betrayal of trust. Jones then sought to derail the plan, bad-mouthing Nathan and disclosing client confidences from past collaborations between JonesWorks and Nathan. While Heath acknowledged Jones's position, he told her Wayfarer would make its own decision after meeting Nathan. So Jones inserted herself into the mix in early August 2024, seeking to box out both Nathan and Abel, who, at least at that time, was still an affiliate. The problem, however, was that Jones had chosen not to be privy to Wayfarer leadership's communication strategies or internal decision-making, having long claimed to be too busy with higher-profile clients. She's the senior partner at the law firm. Wayfarer was fine with Jones's disengagement, as Abel was their trusted advisor. They don't really care. They just like Jen Abel. And they had no interest in being a pawn in JonesWorks' office politics. As Jones tried to stir up drama and undermine Abel's authority, Wayfarer and Baldoni were focused solely on managing the crisis in front of him. But going back to the Hollywood Reporter paragraph that I talked about agreeing with so much, this is another aspect of is anybody in this story or anybody engaged in the making of movies at all a professional? Is anyone in Hollywood actually not engaged in what appears to be high school teenager level drama on every aspect of this business? There are hundreds of millions of dollars at stake in making a movie like It Ends With Us. It was the 17th highest grossing movie of last year. It made tons of money. It's one of the reasons why Justin Baldoni and Blake Lively might both be fine after all is said and done here, even though there are red flags aplenty on both sides of these equations with respect to what kind of set Justin Baldoni runs, what kind of team he keeps, whether he actually goes to the contractual and procedural requirements of making a major motion picture like the one that he did, and of course on Lively's side, whether she seeks control and will seize control of creative endeavors using distributors or anyone else to get her way. At the time, Lively's and Baldoni's teams had negotiated an uneasy truce in which neither side would participate in negative coverage of the other. Lively's team had already broken that truce, but the Wayfarer team did not know that then. On August 8th, 2024, Jones, in another desperate attempt to reinsert herself, contacted a Daily Mail reporter about a story they had published about Baldoni and Lively. She did so in direct violation of Abel's instruction not to talk to the press given the truce with Lively's team. Nonetheless, Jones bragged to Wayfarer about trading calls with the Daily Mail in an effort to appear engaged on the account. I don't know why the Daily Mail is so interested in this story. All of these things seem to relate to a Daily Mail reporter or two. This blatant disregard of Wayfarer's strategy sparked a chain of unfortunate developments. Sloan and Sony learned that someone from Baldoni's team had been communicating negatively to media. It was clearly Jones, and Wayfarer's leadership was livid, as was Sony. All parties were desperate to prevent an all-out slugfest between Lively and Baldoni. Well, mission accomplished there, right? In response, Wayfarer instructed Jones to cease all activities on behalf of Wayfarer and Baldoni for the time being, and to let Abel and another Los Angeles-based JonesWorks employee, Matthew Mitchell, that's a name, right? Matthew Mitchell handled the crisis alongside Nathan. So like I said, I think they spend way too many paragraphs and too many pages explaining this situation to get to this is how the information got into that complaint. But I didn't write it. Yet Jones panicked about being blamed, refused to be sidelined, insisting that she needed to contact Sony and Lively's PR teams to clarify that she had not planted any negative stories about Lively. Heath told her not to do that, to which Jones responded that she could do whatever she wants to clear her name and that Wayfarer could not stop her from making calls. That's true, but if you have a professional relationship, sometimes you have to listen to what the client wants, right? I've talked about it in Virtual Legality, certainly on this channel and otherwise, that the job of the lawyer as a professional representative is essentially to go out there into the fields of battle, whether it's contract negotiation or litigation, and represent the client's interests. It's not to just be whatever I want to be in that context. It's the client that is the real power there. Even when we talk about these lawsuit documents, it's not like Blake Lively or Justin Baldoni wrote them, but I still refer to them as Baldoni's allegations or Lively's allegations because the lawyers did the writing and are just representative of the true power, which is the client. So yes, Jones can go out there and say she can do whatever she wants. Absolutely she can. And Heath and Wayfarer and Baldoni and everyone else can say, well, that's fine, but we don't want you to represent us anymore. We don't want to be a client of your PR firms anymore. Although Jones ultimately agreed to stand down, Wayfarer and Baldoni had lost all trust in her. After parachuting in for self-interested reasons, nearly blowing up the truce with Lively's team, and lashing out when told to stop, Jones became a magnet for drama when it was least needed. But Jones was not ready to throw in the towel. Ironically, it was Jones, not Wayfarer, Baldoni, Abel, or Nathan, who started advocating for a more aggressive public relations strategy. And here's Stephanie Jones. We saw some of this in the complaint document. We have to fight for every story. We saw her saying flood the known zone with positives, prepare alternate stories, etc. Again, normal PR speak. I really don't think it fits into what Blake Lively is trying to say in the California complaint. But it is noteworthy here in the context of this document that it's Stephanie Jones, separated from Wayfarer and Baldoni, at least as they put it in this story, that is doing the claims of needing to escalate the PR war rather than Baldoni and Wayfarer themselves. She doubled down in an email on August 21st, 2024, threatening that Wayfarer and Baldoni had an exclusive contract through May 2025. Said another way, don't you dare think about firing me because you're signed up with me exclusively. That's not really going to have full effect in the United States because it's a personal services contract. And so you're not really going to be able to force people to be your clients. You're not really going to be able to force people to be your PR person just so much you can't force someone to be your actor or actress in your movie, right? Even if you have a certain contract signed up, probably you're still going to be able to get out of that in most contexts. And we can't look at the contract in front of us right now, but this is essentially the saber rattling of someone that knows they're about to be fired and is trying to not be fired. As September drew near, Wayfarer and Baldoni, with the assistance of Abel and Nathan, continued their tireless efforts to promote the film, put out fires, and see the project through to the finish line. Knowing she would soon be terminated, Jones started taking steps transparently intended to make it harder to cut her loose. Those steps included sending email after unwelcome email to Heath and others, long after the relationship had irrevocably ruptured, to lay the groundwork to contest that she had been detached and unresponsive for years. This was especially galling, as Jones had been in Europe and largely incommunicado, save for her disastrous efforts at self-preservation for weeks during the critical month of August when the film premiered. For Wayfarer and Baldoni, the decision was straightforward. As soon as Abel was out at JonesWorks, Wayfarer was out too. This was not about Abel poaching Wayfarer or Baldoni, nor was it a part of a premeditated plan to cut out JonesWorks. But Abel was a trusted, loyal, and committed member of the team. In fact, I think the most likely story for why we've got these huge number of paragraphs and pages about this are that Jen Abel is still someone that Wayfarer and Baldoni, who are paying for this document to be drafted and filed with the court, want to be seen as defending and protecting. Wherever she went, Wayfarer and Baldoni would follow. On the other hand, Jones was a walking disaster whose self-absorption, disloyalty, and insubordination had been a significant headache. For Jones, stewing in indignity and resentment, the loss of yet another client, to Abel no less, was a sting too great to bear. And so she chose to take revenge on all of them. I don't know if they did enough foundational work here of, I don't care about Wayfarer, I don't care about Baldoni, I don't care about Heath, but now I do. So I'm going to launch a huge international revenge campaign against you all. But they did kind of establish it as a Jerry Maguire kind of situation where she's running out of clients. We're at the last straw here. Recall that Jones had taken possession of Abel's personal phone. Again, if you have to say recall in a context like this one, in a document like this one, you've probably written too many paragraphs. On information and belief, Jones approached Lively's team with an appealing offer. Ammunition sufficient to destroy Baldoni, Wayfarer, and Abel in one fell swoop. Wielding reams of Abel's private communications, which could readily be sliced and diced to construct a false narrative, Jones had quite the pitch for an embattled Lively and her team. Knowing that Lively was convinced, wrongly, that Baldoni, and not her off-putting public appearances and cynical self-promotion, had been responsible for the rash of negative publicity directed towards her, Jones correctly assumed that she would find willing conspirators in the Lively camp. Now, interestingly here, this essentially says that Lively's telling the truth when she makes her claim about retaliation, and could even be telling the truth when she makes her claim about sexual harassment, which is to say, whether or not she is wrongly or rightly in the position of being convinced about these things, if she does believe them, that gets her out of certain concerns with respect to defamation and other things that require her to be thinking that something is false on its face. In turning over these materials to Lively, Jones knew full well that the blowback would also engulf Wayfarer and Baldoni, and that was the point. Revenge. Her plan worked like a charm, at least for a time. Working hand in glove with the New York Times, Lively concocted a fantastical narrative that laid the blame for her travails exactly where she believed it belonged, with others. The ramifications of this scheme have been grave for Wayfarer, Baldoni, Abel, and Nathan, who became objects of public scorn and derision overnight. Abel and Nathan, two private individuals and female small business owners, have had their lives turned upside down. And again, I highlighted that just because this is the kind of document this is, right? Again, Justin Baldoni is the client here. We've seen him want to make these particular assertions because he does have strong beliefs about feminism and females in general. And that's one of the reasons why he was so susceptible to a sexual harassment complaint or a fat-shaming complaint, or however you want to frame it, against him in California or in federal court on this score. But these are the lawyers drafting things on behalf of their client and wants to point out female small business owners. Yep. And Jones still has all of Abel's private photos and text messages, which Abel has every reason to believe will find their way online via Jones. Some already have. Yeah, chances are you don't want all of your personal communications, photos or otherwise, to just be out there in the hands of someone who has declared themselves to be your enemy. And so I can certainly understand that. This is a nice bit of narrative making here, but I'm not sure it actually informs too much of what we care about here, which is the case against Lively and Reynolds. So that was a sojourn for a number of pages, and we will take a step of a break right here before we get into the last bit of seizure here, which is Blake Lively and Ryan Reynolds apparently trying to get Baldoni and Heath and Wayfarer to sign a statement that says all of the faults at heart in the making of this movie are theirs and not anybody else's. Let's see what you all have to say about that and more. First is Bubbles. This legal complaint reads more like a Reddit post than a legal document. Again, there is no doubt in my mind that all of these legal documents that we have read in this space are media pieces. They're press releases. They are part of a public relations war between these parties, even more than their legal documents. We're going to see how they can make some of the case claims that they can make here, but it's not the strongest case that they could possibly make if they didn't care so much about getting more of their story out there in the world, to have more quotes available to more media outlets in a document like this one. It's the entire reason why there is a website like this, so that they can put out their specific chain of events and people can just go grab quotes much more easily than they can find it on Pacer or otherwise through the federal filing system. So yes, I think it does read like a Reddit post. It does read like a press release. It does read like whatever else you want to describe it as, more than a traditional legal document. It's one of the reasons it's 200 pages when it could be 20. And that is not incorrect in your assertion. Lucy Furia says, this quote is so applicable, every accusation is a confession. Nathan and Wayfarer are the perpetrators of sabotage and campaigns fueled by revenge. It's possible, Lucy Furious. As I've said in this space, I think you can look at this set of events and say, well, you keep saying that she's lying, you keep saying that she is just completely misframing the issue, but you are also admitting to various aspects of what she is saying as having happened. Right? You are admitting to the video being proposed. You are admitting to saying hot or sexy or saying something about a onesie or all these various other things that are part of the stories at play in both the complaint and essentially the countersuit document here. And you can look at it and say, well, maybe she legitimately felt like she was put upon. Maybe she legitimately felt like it was a harassing situation, that it was a hostile work environment, and that this countersuit and the kind of deluge of public relations campaigning from Team Baldoni is an unjust protection of their guy who should rightfully be castigated for creating this workplace environment. I don't think that's as likely as the story that Baldoni's team tells in this document, but I do think that that's a possibility, and we can't just take the value of that possibility to zero based on what we've seen so far. And Just Because, a member for 30 months, thank you for being a member for so long, Just Because, I really appreciate it. To be fair, Baldoni's prior directorial features were aimed at teens and young adults. I don't know that. That might be the case, Just Because. Even if it is, it doesn't get out of making movies in the way that you have to make movies or any other production in the United States or otherwise, which is to be careful about how your employees are treated, certainly better than how Stephanie Jones is described as having treated her employees in this document, and having that all come under your purview. I do not think Justin Baldoni and Jamie Heath and Wayfarer's failure to keep a tight set, failure to keep the proper documentation and procedures, failure to have lawyers fight their fights that needed to be fought with respect to things like the protection document that we saw described earlier in this document and last week in Videoland, are things that you can ignore. I think Justin Baldoni looks like someone that didn't run a tight ship as a set. Doesn't look like someone who can deal with heavy-hitting personalities, looks to have fled to Sony to protect him. And sometimes that's not enough. There are problems with trying to be the cool mom. There are problems with trying to be the best friend teacher. And if that is in fact the case, some of this, if it happens exactly as he describes in his document and not as Blake Lively describes in hers, are still going to fall at his feet, are still his problem, are still his fault, even if they might not be illegal, they might not be harassing or creating a hostile environment. Thank you so much for the support, Just Because. All right, folks. Well, with that said, I think I've caught everything that I wanted to chat with you all about as I saw it passing by in the chat. Again, I'm just one person, so if there's something that you wanted me to flag or discuss, label it with an @Hoeg Law or a question, and I will try to see those things as they fly by. Otherwise, I'm going to proceed now with paragraph 247 of our legal complaint. All right. Lively and Reynolds threaten plaintiffs unless they take the fall. Again, a lot of novelistic writing here. On August 12th, 2024, Heath and Abel had a call with two executives from their then talent agency. One admitted that the root of Lively's problems was focusing the promotion of the film on frivolities like fabulous premiere dresses, Hollywood glamour, and the commercial benefits for Lively's brands, while Baldoni had always maintained his public focus on amplifying the voices of domestic violence survivors. The executive communicated the demand from Lively and Reynolds that Wayfarer, Heath, and Baldoni make a public apology that day, and that if they failed to do so, the gloves would come off. Stunningly, the executive even told Heath and Abel that Lively and Reynolds objected when Baldoni spoke kindly of Lively in public, claiming that it misrepresented their relationship. Hurts their case. The talent agency executive told Heath and Abel that Lively believed Wayfarer, Baldoni, and Heath were waging a shadow campaign against her. So the pieces of the New York Times article, the pieces of the California complaint, and ultimately the federal lawsuit are in place relatively early on. Whether or not that's true, whether or not that's factual, reasonable minds can differ on that. But what we do know, at least as described here in this document, is that they were moving forward with this notion that there was a retaliation campaign, that all of this negative press, all of this harm to her image was being done by Justin Baldoni and Wayfarer instead of as a result of her marketing efforts. The second executive admitted on the call that no one pushes back on Lively and Reynolds. One executive told Heath that the agency had spoken to Lively and Reynolds by phone about the overwhelming tide of negative publicity that they had faced over the past days. Heath clarified that Wayfarer, Baldoni, and Heath had no connection to the negative publicity, but they told Heath that Lively and Reynolds had demanded that Wayfarer put out a statement accepting blame for the problems during filming, with an express threat that they themselves would attack Wayfarer in the press if Wayfarer refused. The executives told Heath and Abel that Reynolds and Lively dictated a statement that they required Wayfarer to put out, calling It Ends With Us a troubled production and forcing Wayfarer to take accountability for the problems in the production. Wayfarer, Baldoni, and Heath would have to acknowledge and own their mistakes and own all negativity being aimed at Reynolds and Lively. Abel and Heath asked that the executives clarify what exactly Wayfarer, Baldoni, and Heath were being asked to take accountability for. They admitted, and again, this is just a game of telephone, right? This is a legal document drafted by Baldoni's legal team about what this conversation entailed from these other people, and they claim that the executives admitted that Lively and Reynolds were simply upset by how social media had turned against them. He admitted that making constant threats was Lively and Reynolds' well-known modus operandi, and that their demands were not based on reality, but on finding someone to blame for their social media crises besides themselves. And again, as we've seen with the way that people communicate in Hollywood, this could also just be placating this other party, right? These could be executives that are responding to Heath and Baldoni and Wayfarer's upsettedness here and saying, oh yes, no, it's definitely not necessary. It's just that these guys are crazy, right? There's a lot of that going on in these communications. And so I don't know that we can take this on its face any more than we can take anything else, which is to say, people in Hollywood, whether it's Stephanie Jones or these unnamed executives, have a tendency to ingratiate themselves to the people in front of them at the expense of the people that are not in the room. So I don't know how seriously we can take this, but the claim is that even these other executives, who wouldn't otherwise have an obvious bias or reason for bias in their conversations, were saying that Lively and Reynolds were the ones responsible and that they were trying to force this on them in order to protect themselves. When plaintiffs refused to take the fall for Lively's disastrous promotional campaign, Lively was true to her word. The gloves came off. Months after the film's premiere, on December 21st, 2024, a bombshell article dropped in the New York Times. And we know it well. It's what brought us all together here. Authored in part by Megan Twohey, who gained prominence for the expose of Harvey Weinstein, the article's headline promised a glimpse inside a Hollywood smear machine. This is what we call the article. The article purported to provide a detailed account of a calculated campaign to bring down Lively in retaliation for daring to speak out against sexual harassment on the set of It Ends With Us. The article draws heavily from the California Civil Rights Department complaint that was filed by Lively the day before and reported on by a bunch of outlets as a lawsuit, which it's not. The CRD complaint and the article are both purportedly based on thousands of pages of text messages and emails that Lively obtained through a subpoena. The article notes, these and other documents were reviewed by the New York Times. Again, we're using part of what we did to draft against the New York Times in our California lawsuit here. The 4,000 plus words of the New York Times article dropped less than a day after Lively apparently filed her CRD complaint. And I pointed out that timing. The reason that this article jumped out at me when I was reading it over the holiday break was that it was so obviously leaked by one or other party, and it only made sense really to come from the Lively side of things. The close coordination between Lively's team and the New York Times, likely over a matter of months before the CRD complaint was filed, is plain. The article refers to the 17-point letter of production conditions that Lively insisted upon. While the reasons for making many of those demands were mystifying to plaintiffs at the time, again, are you getting legal counsel? Do you have a lawyer? Because I could explain to you why you draft things in that way at the time, before all this happens. It became clear that Lively had ceded her revenge more than a year before. By insisting on superfluous or already existent protections, Lively laid the foundation for her baseless claims of pervasive sexual harassment. I really like this story for virtue of talking to my clients about why you don't just agree to language that doesn't seem to harm anything, because you can easily harm yourself if you don't try to make it as accurate as possible, even things that are innocuous, like the recitals to a contract. When she buffaloed plaintiffs into agreeing, she sealed the perfect narrative poison pill, allowing her to later claim that plaintiffs' agreement to the 17-point letter was proof positive that sexual harassment was endemic on the film's set. But Lively had to explain away the self-inflicted mountain of bad press she had brought down on herself, as discussed elsewhere herein. This is all described like the end of a Columbo. But Lively still had a problem. On information and belief, Lively and her team used cherry-picked text messages stripped of context and even manipulated to peddle a narrative that plaintiffs had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation through a shadow smear campaign. Apparently, The New York Times credulously accepted the narrative wholesale while making little or no attempt to investigate the veracity of that narrative. And we looked at the New York Times lawsuit that's in the second video of this playlist, and one of the things I said was that the actual theory of the case brought by the Baldoni side against the New York Times probably wasn't going to carry water, and it's rearing its head here again, which is to suggest that the New York Times owes some certain level of investigation to claims that are brought to it by a direct source, and that is not the responsibility of the media. I think that's important to understand because you might think that there's some kind of legal responsibility. It's an ethical responsibility to go get multiple sources to go and do this investigation. It's an ethics claim. It's not a legal claim. And the New York Times has every legal right to essentially depend for purposes of defamation on the first person account as filed with the state of California of Blake Lively in respect of these things. I think it's bad reporting. I think it's a bad story. That's one of the reasons I wanted to talk to you all about it. But it's not a legally defamatory one, or at least not obviously so to my eye. By telling the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish that false story, Lively and her co-conspirators committed the tort of defamation. But again, just before this paragraph, you said that Lively wrongfully but truthfully thought these things, thought there was a revenge campaign, thought there was sexual harassment. And if she does think those things, it's very difficult to win a defamation case because we're talking about a claim that has to be that she knowingly made false statements, right? That Justin Baldoni is a public figure for purposes of this conversation, for purposes of the conversation around domestic violence or sexual harassment. And so you're going to have to show that the person making the statements knew them to be false when she made them. And in this particular context, I was sexually harassed. That's a state of mind that essentially exists in her own head. And so that's going to be very difficult of a claim to bring. Now, notably, I said this very same thing as analysis at the start of the Johnny Depp versus Amber Heard trial. Before I had seen any of the evidence, before I had heard any of the testimony, you can go back to those videos on Legal Bites' channel and see me saying this is an extraordinarily difficult defamation case to win because for the most part, Amber Heard in that Washington Post op-ed is simply stating what she feels is her own victim status, and it implies certain things, which was of use to them in the state of Virginia, but it doesn't establish clear wrongful statements in most instances. Now, in that particular case, it got away from her when the actual stories that she was telling in court wound up sounding more and more increasingly unlikely. But overall, the New York Times does not have an objective legal responsibility to investigate or otherwise to question or be curious about the claims made by a primary source, even if we might like them to do so. For example, Lively's CRD complaint, which on information and belief she provided to the New York Times long before filing it, and this is where I believe the amended complaint really changes some stuff because they have some data entries from metadata in the photos used in the article, references text exchanges between Nathan and Abel as purported evidence that Nathan planted a negative story in the Daily Mail titled, "Is Blake Lively Set to Be Canceled?" Lively's portrayal is categorically false, misleading, and devoid of factual basis, yet knowingly propagated to the Times. The text exchange shows Abel responding, "Wow," followed by, "You really outdid yourself with this one." This is the emoji conversation. We know this from a couple videos back. To which Nathan allegedly replied, "That's why you hired me, right? I'm the best." But the information Lively fed to the New York Times was apparently selectively and deceptively edited, resulting in a gross misrepresentation that actually reversed the sarcastic meaning and tone of the messages. Again, I don't know that there's any reason to believe that the New York Times was looking at anything other than the complaint filed with California. There's nothing in that article that doesn't appear in that complaint. I know that they claim that they had access to potentially thousands of documents. I think that's what was told to them by Lively and her team as to what the complaint was based on, and I think it got a little bit misreported as it went on. That's not great for them, but we get back to this upside-down emoji. I'm not sure the New York Times ever knew that it was struck out, and it's certainly a difficult case to bring if you can't put them in possession of the upside-down emoji, regardless of what they published. Lively, who apparently collaborated closely with the New York Times on the article covering her CRD complaint, must have known that the text messages were unscrupulously altered and selectively edited, enabling Lively and her team to propound a false smear campaign narrative designed to destroy plaintiffs for the Times' knowing or reckless dissemination. Specifically, in the immediately preceding text message exchange on August 16th, Nathan forwarded a screenshot of a message from a reporter informing her for the first time of the Daily Mail article. In response, Nathan had wrote, Damn, this is not fair because it's also not me. Followed by everything now looks like it's me. Perhaps unknowingly, Nathan was already anticipating the accusations that would soon be leveled against her and her fellow plaintiffs. And again, we've already discussed this particular argument, but they didn't include the upside down emoji, which indicated that it was a sarcastic conversation. It really does look like a sardonic, sarcastic conversation in my reading of what they present in those photos. And this is that PR war kind of aspect of things. And it is one of those places where I think the lively complaint probably does overstep and describe things that didn't happen in exactly the way they're describing in that complaint. And a reasonable mind can look at that and say, I'm going to discount everything else she says in every other context because she's clearly willing to overstep on this particular point. A reasonable mind could also say, well, this is a little bit of angels on the head of a pin. This doesn't mean that everything else that she has said is wrong. And those two reasonable minds, they can differ on this score. And so I am totally open to those reasonable minds existing and not disparaging the humanity of either one of them, even though I am more compelled, to be honest, by the Baldoni description of events right here. When read in full, the exchange reveals Nathan and Abel engaging in facetious wry banter. I'm not sure if it's wry, bordering on gallows humor in response to their predicament, not conspiring against Lively. Lively, and in turn the Times, misrepresented these communications to support her salacious and unfounded smear campaign narrative. This calculated distortion underscores Lively's duplicity. Any negative press about Lively was unequivocally a consequence of her own actions. Even the Times itself acknowledged Lively's public missteps in the August 17, 2024 article titled "It Ends With Us, the Press Tour Drama Explained." In fact, they acknowledge it in that December 21st article that is at the heart of this defamation complaint. In it, reporter Shivani Gonzalez observed, Lively's promotion of the movie has included a push for her new hair care line, discussion of the clothes in the movie, and response to questions about abuse, which have been criticized as shallow and tone-deaf. Baldoni, by contrast, has emphasized the importance of raising awareness of domestic violence and providing resources for those in similar situations. And there is no question that Blake Lively had a lot of negative press around the marketing of this movie. The question, for purposes of the lawsuit, and her lawsuit in particular, is whether or not that negative press was artificially created in some important way by Justin Baldoni and his team, and if they did that in order to cover up their sexual harassment and retaliate against reports of their sexual harassment made to the state of California or otherwise. And I think there's a lot of steps to go between what Blake Lively has put in her documents and establishing that there was a hostile workplace, that it was a harassing environment, that they then took the reports that she made to themselves and to the state of California about harassment in a hostile workplace and said, we got to retaliate. I'm not even sure that there's any evidence on either complaint or in any narrative that a PR campaign against Blake Lively actually took place. And without that, you can't get to retaliation. As noted elsewhere herein, Lively's marketing efforts, which included encouraging audiences to grab your friends, wear your florals, while promoting her hair care and alcohol brands, were widely criticized as insensitive. And this is more kind of doubling up on that particular point. She did it to herself. The contemporaneous communications of plaintiffs show growing awareness that they were being set up to be blamed for Lively's disastrous missteps. God, I'm so over this. I'm sure Leslie thinks we placed this one as well. More text messages, more text messages. Again, I think a lot of these are included to essentially get ready to establish that timeline document that they wanted to put up on their website. They wanted to be available to the various people, whether it's media or just folks, to understand their side of the story, their position. And then we get into the actual lawsuit type language. Who are the parties? Do you have jurisdiction and venue? Yes, they undoubtedly do. And then we get into the causes of action. So we're going to talk about law. I've got some law to discuss with you all. I've got some jury instructions, as I know you all love here when we go into those things. The very first and the biggest cause of action that they bring is civil extortion. We're going to talk about that at length as soon as we come back from our little document break. So, folks, how you all doing? Jetty Jess says, Depp v. Heard was such a unique situation for defamation, I don't know that this will replicate it or have a similar outcome. I don't see this going to trial, Jetty Jess, and thank you so much for being a member for more than 2 years. I really see this one settling. I think ultimately this will burn itself out, and enough of the material has gotten out from both sides that they can at least claim a certain amount of victory and probably save face in the long run if there's a settlement and they both agree to essentially amicably state that nobody's to blame for any of this at the end of the day. I really think that'll happen when one or both of them has the opportunity to get another gig, to make another movie, to make money for the studio that wants to back them up. And that studio says, this cannot be ongoing throughout that whole process, or else we're not going to support you. I think that's when that leverage position takes place. That's what I see is happening most likely. It's not a guarantee, but that's what I see right this second. All right. Against the Tide, awesome mod, always here to support us. I gave her absolutely no heads up that we were even going to be doing this today. Already in there, keeping track of things, making sure everybody has a reasonable mind in there. It says, before this, I don't think I've heard the phrase term buffaloed into this, unless I heard wrong. No, buffaloed, that you can use that way. Buffalo can be a verb. That's how you get the famous buffalo, 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 which is an effective sentence that uses the same word multiple times because it can be a noun, it can be a proper noun, it can be a verb. Lots of fun with buffalo, folks. Have fun with it. Everybody except the Bills enjoys buffalo. Have fun with it. All right. I see some political discussions behind the scenes here in the chat, but I don't want to get into any of those right now. I do appreciate everybody kind of talking about this issue in a reasonable way because it is one that people get really passionate about. Catherine says the Sabres aren't too keen on the phrase. I suppose everybody that's left Buffalo doesn't love the Buffalo sentence. That's fine. Jody Jess says, I always enjoy the crazy wordings that come out of these cases. I swear I learn new vocabulary every time someone in Hollywood sues someone else. One of the reasons that I wanted to talk about this particular case so long in Hangouts and Headlines is that I think that Hangouts and Headlines really is about looking at the way media can be manipulated, looking at the way narratives can develop. And I don't know that we've ever seen a set of lawsuits or cases here that so transparently shines that spotlight on how all this plays out in real practice. I think that talking points document about how marketing works and what we want to avoid and how you should think about these things and how those interviews that you see online of the actors or directors or anyone else associated with the movie is enormously helpful for folks to understand how many hands are baking the pie in this particular instance, how many folks are interested in this, and that should be evident whenever there's hundreds of millions of dollars on the line. But I think people do take at face value some of the things that actors or actresses say in the context of one of those studio interviews. And I think that's important to understand. I think it's important to understand how smaller studios make movies. Wayfarer is not tiny. This is not their first movie. And this is certainly a major success. But it is effectively a few guys with one multi-million-dollar financier. And so they aren't necessarily following the full multi-lawyered, huge international Sony Pictures level. We've got handbooks on top of handbooks to control procedure type of way of making a movie. It's a little bit more ad hoc. It's a little bit more laissez-faire. And so I think it's important to understand that that's the real way that movies get made. That's the real way that things get made in the world, right? I have a little bit more context with respect to software development in people making enterprise software and people making entertainment software, and how small that team can get, how outside the bounds of kind of corporate structure you can be and still get things done. But it can all blow up if you've got one personality or more that gets in there and upturns the apple cart. And so I think that's an important part of the story. I think it's enormously useful to understand how the real world works. And that's what this channel, Virtual Legality and Hangouts and Headlines, have always been about from my perspective. Lady Gray says, Hoeg, do you think we'd be here without Depp v. Heard? I think he kind of made it palatable to the public as a man to go out and defend yourself. Not sure that this would have happened in this way otherwise. I agree that Depp v. Heard is the template for saying, I'm going to have to stand up for myself. It's one of the reasons why I, at the top of this video, said I'm not sure the Hollywood Reporter is exactly right to say they're both moving towards mutually assured destruction. We're all sick of everything here. Because I'm not sure if you do feel like you're put upon and you're Justin Baldoni and his team, that you can just go in there and take that New York Times article, that you can just sit there silently and quietly and watch your career explode, right? Just Johnny Depp did show that you can have a certain amount of success fighting these things. I think there is no question that Justin Baldoni and his team have had success turning the tides of the public perception of what's happening here. I think if you go and you look immediately after that New York Times article drops and that complaint is being read by people in late December of last year, you will see everybody saying, oh, Justin Baldoni's a real creep. Oh, he really did these bad things on set. And Blake Lively was just put upon and she needs to be protected and she's an angel. And that was completely flipped by this PR war. Do I love that the legal system is being used for this purpose? No. Do I love that litigation of a 200-page variety is being used to get these documents out there? No. And as we will talk about when we talk about civil extortion and the rest of the causes of actions, do I think this is the strongest case? I do not. But I am sympathetic to someone that thinks that they didn't do wrong. I am sympathetic to someone that feels like they're put upon. And having seen the various things online and reacted to both sets of narratives here, I can tell you personally, I find the Baldoni set of facts to be the more likely to have occurred, to be the stronger, more compelling narrative here. And I don't really have any issue with someone looking at this and saying that Baldoni was the one wrong. I don't have any issue really with the opposite direction, although I find that to be a tougher case. And I would be interested in hearing how people got to that. Okay. Bubbles, you have not been here since the top of the video. I can tell because you are telling us the Hollywood Reporter had an article titled BL and JB March Towards Mutually Assured Destruction. Yes, that is what we talked about at the top of this video. We can go and cover the end of that article if you are interested, I think. We were right here in the middle when we last talked, but that is okay. I did want to also flag that the overall Hollywood Reporter article says, Lively allegedly enlisted Reynolds and Taylor Swift to help squad pressure Baldoni to agree to a scene rewrite while threateningly comparing herself to Daenerys Targaryen, except Emilia Clarke took direction. Burn, that's the actress that played Daenerys in Game of Thrones for HBO. One wonders if there is a case on either side for doing the unthinkable, either settling or pulling their respective lawsuits, because mutually assured destruction has already occurred. It's a weird framing for your article headline, honestly, because if it already occurred, they aren't marching towards it. They're essentially marching around it or out of it. The reason each side keeps going is to punish their respective arch nemesis and salvage their reputations. Maybe, again, I think you can look at this like Depp v. Heard, if you were so inclined towards the Baldoni side of the narrative, and say, in this situation, that's a man defending his reputation, yes, but it isn't obvious that he's seeking to punish his arch nemesis as much as this is what is the necessary pushback to what he feels is an unjust complaint against him. And you don't have to agree with that, right? You can say Lively's in the right and Baldoni is not, and this is all just trying to run her down for seeking legal redress for making her uncomfortable on set. But if you side with the Baldoni part of the narrative, I don't think you can say that this is just him attacking his arch nemesis. There's something to be said for getting out from behind lawyers and publicists and strategists and telling the public, I told the truth. I also wish I handled things better. I don't want to continue fighting a toxic person. I'm going to trust that I will eventually be vindicated. The real race here isn't legal after all, but the one to look like a non-nightmare grown-up and to protect their future business endeavors. Here I agree with the Hollywood Reporter insofar as I do think that both Baldoni and Lively have tarnished their image on this. And I think that Baldoni, even if you take everything that he says in his lawsuit as sacrosanct truth, descended from heaven as the God's honest platonic ideal of truth, that he still looks like he's not a great producer, not a great director, not someone that can handle big voices and big personalities in his actors or actresses, and that I would be at least a little bit reluctant to give money to as an investor. Although, if I'm a Hollywood investor, I may be convinced by the success of the movie, although maybe a little bit less so if I think that it's Blake Lively's cut. So there's a lot of things going on there. But yes, the object here, if you're Lively or Baldoni, is to escape this quagmire with some notion that I can be a professional now and in the future. And lawyers get paid either way. And the lawyers are not necessarily going to tell you that you should settle or otherwise not litigate this, but I suspect that that's where we ultimately wind up. The argument against this strategy goes back to Depp v. Heard, coming back to the comment that led us here, where courtroom victory admittedly helped Depp shake off some of his canceled vibes. In Lively versus Baldoni, it's hard to imagine a win makes either plaintiff look that much better given all that's out there, but it might. In truth, each has more in common than they might realize. They're both being used. Their lawyers get money and publicity. The media gets content. Readers and fans get the latest tea so that they can judge and debate. Everyone is insatiable for more. Nobody wants this season of feud Lively versus Baldoni to have its finale anytime soon. Objection, Hollywood Reporter. I'd be cool if they stopped suing each other. There's 600 lawsuits every day. As a card-carrying member of the press, it would admittedly be terrific if both sides kept battling, going back and forth forever like the Joker proposes to Batman at the end of The Dark Knight. But none of this seems to be much helping Lively or Baldoni. It's just Hollywood's best show for the rest of us. And I think that that's fair right this moment, where they're clearly at roughly equal ground, fighting each other with a similar volume. But certainly at the moment when the complaint drops in December of 2024, I think Justin Baldoni has taken great strides to improve his public image to where it was when that story dropped. And maybe now it's not something you have to pursue all the way to the end. Maybe you do. But as of that moment in time, I think his PR campaign has been very successful to get even to this level of relatively even standing, if not a preferred standing for Baldoni against Lively in the court of public opinion. So yes, I did see that article, Bubbles. I'm glad you mentioned it because I did want to cover the end of it before we got too far. But yes, that was a part of what we discussed at the top of this video and will continue to discuss into the future. But before we do, let's talk about some law. Because what are they actually suing over? They told us a nice story. We're 180 pages in. What are we actually suing over? What is the legal redress we are seeking from these people? The first is civil extortion. And I mentioned it earlier, but the word civil here is being used to separate extortion from criminal extortion, from when the state has an issue with you, when you've threatened somebody and they're seeking to put you in prison. Civil extortion is seeking damages. And I'm not a California lawyer, so as I do, I went to look at some sources for what this looks like in California. I did find a California lawyer that has some materials out there. What is the definition of civil extortion in California? Who says it's the same as criminal extortion, the obtaining of property from another with his consent, or the obtaining of an official act of a public officer induced by a wrongful use of force or fear or under color of official right. And the most important word in that definition is wrongful. I've highlighted it in red right there. You obtain the property of another with his consent, induced by a wrongful use of force or fear. So they agree to give you what you're asking for. You say, give me all your money or I'll shoot you in the head. That's extortative. That's extortion, right? In this particular case, the claim is that Blake Lively had a contractual obligation of some kind to do the various things that she was supposed to do, or at least an obligation to not seize aspects of editing or producer credits that she didn't otherwise earn. And she withheld her contractually obligated marketing efforts and otherwise threatened Baldoni, Heath, and Wayfarer with a sexual harassment complaint in order to seize control of the movie. That's the consideration. Whether or not you agree with this entirely is going to be a reasonable minds can differ type situation, I'm sorry to say. What level of fear is necessary for extortion? Well, the fear has to be one of these various things. We can actually see it in the California law itself here. Fear that will constitute extortion, again in the criminal code here, and I'm not responsible for California's lawmaking. I'm going based on the research that I did and saw for civil extortion as described by these California lawyers. Says the fear will include or may be induced by the threat to expose or to impute to him or her a crime or to expose a secret affecting him or her. And if you threaten that and get money or other consideration, something of value from that person, that could be extortion under the law. There's a whole lot of things that go into that and a whole lot of areas where something that you do might not be extortative depending on how far you go with it, which is where this kind of gets into the gray area. What if the defendant had the legal right to carry out the threatened actions? It's not the be-all, end-all issue in California. People have the right to report wrongdoing to the police, their company's human resources department, and so forth. But just because you have the right to do something, it doesn't mean you have the right to demand money not to do it. For instance, people have the right to post negative reviews on websites such as Amazon and Yelp. That right is protected by the First Amendment. But you can't threaten to issue negative reviews in exchange for cash payment because that's extortion. Can't someone ask for a settlement in order to avoid a lawsuit? This is one of those areas that gets really dicey and gray area. Yes, if the intent is to resolve a good faith dispute without litigation. However, the threat of legal action without the intention of taking it may constitute extortion. Note that the person making the settlement request does not need to be right that the claim is winnable, but it must be made in good faith. And again, this is legal advice or legal information from another source with California as their backing. So we take it with a grain of salt, but the important part here is that civil extortion as a concept is one that requires a threat of some kind. Defendants made threats to plaintiffs that they knew to be wrongful, including threats to breach contracts, defame plaintiffs, and injure. And then this sentence just dies. I don't know where it goes. There's no rest of the sentence. Defendants' threats included demands that money, property, services, or other sources of value be conferred upon defendants without consideration or contractual entitlement thereto. That's the right to control the creative cut of the movie. Plaintiffs complied with the wrongful demands. Plaintiffs were harmed. Defendants' wrongful threats and demands were a substantial factor in causing the harm. And upon information and belief, all of the defendants worked together so they can all be jointly liable. And they did it with an intent to oppress or defraud. And so we should be awarded not just the damages that were directly caused, but punitive and exemplary damages. Extra money to punish them even more. And if that all sounds fairly lightly sketched, it's because it is. Civil extortion is a complaint that I wasn't actually expecting to see here. It's an extortive kind of fact pattern, but it is not as clear to me as defamation, which has its own sorts of issues, and that's the second cause of action here. Defendants made one or more statements to persons other than plaintiffs, including without limitation to the New York Times, to the effect that plaintiffs engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others. So they made these statements to the New York Times about sexual harassment happening. The persons to whom defendant made these statements reasonably understood that these statements were made about plaintiffs. Yep. Statements made by defendants were intended to do and did have the effect of exposing plaintiffs to hatred, contempt, ridicule, or obloquy, or of causing them to be shunned or avoided, or of having a tendency to injure them in their occupations. Tendency to injure, I think. Specifically, the persons to whom defendants made the statements reasonably understood the statements to mean that plaintiffs engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others. The statements made by defendants about plaintiffs were false, right? In order to win a defamation claim, the statement has to be false. Except, as we've already established here, while there are good arguments to be made that Lively is at least irrational about some of the things that she describes, they have the issue that the things that she describes did happen in some form or fashion in real life. So are they false? Maybe. But the falsity has to exist in her mind about whether she was sexually harassed or not. And that's going to be enormously difficult to prove. Furthermore, defendants knew the statements were false or had serious doubts about the truth of their statements. Defendants' false statements about plaintiffs to third parties were a substantial factor in causing harm to plaintiffs' property or business. Upon information and belief, all the defendants worked together, and they did it with oppression, fraud, or malice, so we get punitive and exemplary damages. And again, I say that it's going to be difficult to prove. I do think it's the easier case than the New York Times, because all the New York Times has to believe is Blake Lively. Blake Lively says these things happen. I already told you that there's at least, in my mind, a shadow of a doubt that she thinks that these did actually happen the way that she's describing. Then, okay, if she believes that, then she can believe those claims. She leaked them to the New York Times, and the New York Times published them because they had reason to believe her. You don't have defamation against anyone. So I think both the civil extortion and the defamation claims are weaker than the people that think Baldoni is in the right here probably think they are from a legal perspective. But again, this is a PR war. This is not as much of a legal fight as it is a PR fight. The same with Depp v. Heard, by the way. The reason you had so much analysis at the start of that case, including my own and others on YouTube, saying that this was an enormously difficult case to win and didn't make a lot of sense to bring in Virginia and all these various other aspects of that particular case, was that it was mostly a public relations gamble. And Johnny Depp won that case in large part because he was able to frame Amber Heard's testimony as wildly unlikely to have happened the way she described it. And in that context, then he wins the PR fight. And yes, it's defamatory under the jury rules because it's likely that she lied about anything else that she might have said. And what she was claiming as her own victim status could be ascribed to those lies and all these various other things that happened. But that state of affairs, that set of circumstances, still enormously unlikely in a legal situation. And even at the end of that case, you heard a lot of us lawyers say, you know, if Amber Heard doesn't testify in exactly that way, if she frames the conversation in a different direction where it's more obvious that she could think these things about her victim status and it's not defamatory for her to think those things, that it would have been a completely different case. That this is still a very difficult legal case to make, even if you believe Justin Baldoni and his side are the ones that are being wronged here. The third cause of action, false light invasion of privacy. Now, this is one of those weird ones. We saw this in Lively's case against Baldoni. This is essentially the dispersal of true, or at least plausibly true facts about people in a way that puts them in a negative light. And this is essentially the same as leaking to the New York Times in defamation land. But here we don't have to prove the falsity. We just have to say that these things harm us because it's an invasion of privacy. There are all sorts of questions with respect to false light invasion of privacy in California and other jurisdictions about what interaction this has with the First Amendment. So the weakness here is primarily that it's the same as a defamation claim, except for the falsity element. And it's not as obvious. We don't have as much Supreme Court precedent on this that you can actually make this claim for revealing information in the New York Times about an issue of public importance like sexual harassment or like hostile workplaces, etc. And that's going to be one of the weaknesses here. The defendants knew the public disclosures would create a false impression about Baldoni, Heath, Nathan, and Abel. And again, we don't even know that Lively thinks these are a false impression. So we got all sorts of issues with proving this particular case as a legal matter. Then we get into the really weak claims. Fourth cause of action, breach of implied covenant of good faith and fair dealing. So we've talked a lot in virtual legality and on this channel about good faith and fair dealing. This is the notion that any contract that you enter into, any agreement that you enter into is made by human beings, and human beings cannot isolate every possible way that you could screw them over with words on a page. And so what the law requires is that every party to a contract have to give a covenant of good faith and fair dealing, that we are going to abide by the spirit of this contract to the best of our ability, even if there might be a loophole that we can kind of squint and squirm our way through. And if you don't follow that covenant of good faith and fair dealing, then you could have an issue under the law. But as you can probably guess just from the way I described it, this is not as strong as a pure breach claim where you have a contract, you have an obligation to do something, and you say, I'm not going to do that. This is essentially read between the lines, and because of that, it is not as strong as that pure breach. Then we have intentional interference with contractual relations. This is labeled as being against Reynolds and Lively. This is really against Reynolds, at least as described above, which is the instance where he goes to the Deadpool premiere and says, essentially, that Baldoni is a sexual predator and that WME should drop him. There was a contract between plaintiffs and WME. Defendants Lively and Reynolds prevented performance of the contract or made performance more expensive or difficult. Defendants Lively and Reynolds intended to disrupt the performance of this contract or, in the alternative, knew that disruption of performance was certain or substantially certain to occur. Plaintiffs were harmed. Defendants' conduct caused that harm. All the defendants can be grouped together, and it was all done with malice and fraud, etc. Then we have the weaker version of that. So that's interference with contract, right? Interference with contractual relations. The weaker version of that in California is interference with prospective economic advantage. And so this is the same set of facts. Hey, Reynolds shows up at Deadpool and says, get rid of that sexual predator. And rather than just needing the contract to be disrupted, you knew that WME was in a relationship with Baldoni that was likely to convey an economic advantage to him in the future. And you disrupted that possibility of economic advantage. Again, an equitable claim, much like the other equitable claims we've already talked about, is weaker than the kind of black letter law claims. Seventh cause of action, negligent interference with prospective economic advantage. So again, going down the weakness spectrum, we've eliminated the contract need. We have an intentional interference with prospective economic advantage. Well, maybe you weren't intentional about it. Maybe you were just negligent in the way that you interfered with the economic advantage. So we're throwing everything at the wall. This is what lawyers do. This is normal in a litigation document like this. But we say if we can't prove intentionality, then you knew or should have known that the relationship would be disrupted and you failed to act with reasonable care. The issue with this is that in order to have the notion of reasonable care, in order to be negligent towards someone, you have to have a duty of care to that someone. And in this particular context, I don't know that Ryan Reynolds going up and telling his agency that they should not work with Justin Baldoni because he's a sexual predator is negligent. It is intentional. Whether or not that intentionality rises to the level of a legal issue is going to be up for a judge or jury to decide. I don't think it necessarily is. But negligence here is just trying to capture the entire umbrella of possibilities for mental state there. I don't think Ryan Reynolds has a duty of care to Justin Baldoni in that context. And so I don't think you can actually assert that he acted with a failure to act with reasonable care. They kind of skip that. Ordinarily, you would establish what reasonable care means here, what that relationship would be in order to establish the duty. They don't do that, so I think this is the weakest. And again, we've talked about it when we look at lawsuits before. That's the general order of operations. By the time you get to the end, the last cause of action is usually the weakest, and it is in fact the case here. We demand a jury trial. Here's our legal document. That was 180 pages, folks, or 179, and we finally got through it. But we've got one more topic to talk about because I'm a crazy person, and I said that wasn't enough for this video. So stick with me for one last thing. I've heard a lot of people talk about the notion of litigation privilege, right? I've seen this discussed online. I've seen this discussed in various parties with respect to claims of defamation against Blake Lively for the New York Times article. And the notion of this goes like the following. Again, California law, a privileged publication or broadcast is one made in any other official proceeding authorized by law. And in the context of this, you can't use a privileged publication or broadcast for purposes of bringing a legal liability against these parties. So in litigation, you see this as when I file a lawsuit against you or a countersuit like the one we just went over, I can't be accused of defaming you for what's in that lawsuit because we need to be able to avail ourselves of the justice system, of the judicial process. And that makes all the sense in the world. But some folks have said that Justin Baldoni can't claim direct defamation against Blake Lively because the primary source material for the New York Times article, at least as of right now, before we know anything specifically, is the complaint filed in California itself, and that's part of an official proceeding authorized by law. The difficulty is with that whole leak concept, right? The theory that Baldoni has put forth is that Lively didn't just file that in California. She actually worked with the New York Times and filed that complaint with them and leaked other information for them to make this article in December of 2024. And that's where litigation privilege, I think, runs aground a little bit. Or, as law commentary says early last year, litigation privilege does not extend to comments in the media. Now, this is not a legal source. This is not something that we have to take as just sacrosanct here. But I did want to point out how this theory goes. And as described in this article, under California law, parties engaged in litigation are not liable for communications made during planned or pending court actions. However, a state appellate court has ruled that comments on defendants' blog and Yelp are akin to press releases and therefore not immunized by California's litigation privilege. Vanessa Hamilton, the defendant, made several disparaging comments against Paglia and Associates, the construction company she hired to repair the damage suffered by her home when a tree fell on it. The company does business under the name Protect Construction. Protect had been recommended by her insurance company, but Hamilton was dissatisfied with the quality of repair work. As a result, she reported the company to the Contractor's State License Board, which she believed would immunize her from defamation suits by the defendant. So, much like in our current situation, this person has a problem with somebody that she's worked with, and she filed a complaint document with a board or other agency in the state of California. Although Hamilton won her case before the board, she was not satisfied. She began posting negative reviews of Protec in 2019 that claimed the contractor failed to properly level her front and backyard, install attic vents, and provide a proper driveway width. Her posts included comments that Paglia had committed hard fraud and turned her life around. Hamilton claimed that her comments were privileged under California Civil Code 47B, which says statements made and things said or done in connection with a planned or pending court action are considered privileged, and no legal action may be brought to collect damages from such statements or actions. Again, this is a good idea. We want people to be able to avail themselves of the court system. Litigation privilege overall, good idea. Justice Wiley disagreed with Hamilton's characterization of the privilege, stating the litigation privilege does not cover statements made entirely outside the litigation context. Using the internet to speak publicly is every American's right, but if people wish to defame private figures online, they do so at their own risk. In our case, it would be a public figure, different standard, but same kind of deal. The opinion went on to discuss the legal standards for special motions to strike. In her defense, Hamilton asserted the litigation privilege because her posts related to a matter under consideration by a state agency. Wiley disagreed, holding that her online postings were not sufficiently connected to this agency's proceedings. Instead, they were like press releases, efforts to communicate with the public at large. The litigation privilege does not protect press releases. It did not protect Hamilton. And so this is not precedential. This is not definitive. This is essentially a denial of a motion to strike for anti-SLAPP purposes in the state of California. But it is useful for understanding what this fight might look like. There is no doubt in my mind that Blake Lively and her team will at least make a motion to say defamation isn't allowed for litigation privilege. But the fight is that if a press release is not protected in California, and there's no reason to believe that it would be, there's certain fights in different jurisdictions about this particular topic with respect to litigation privilege. If a press release isn't allowed, then this has the same effect of a press release. If the notion of a press release is we're going to get people to report on this, then directly interacting with the press source is the same as a press release for this purpose. And the fact that you filed those same allegations with the state of California doesn't get you out of what it is that you said to the New York Times. And that's going to be a fight. Lawyers aren't going to love that because lawyers are the ones that are potentially liable in this particular instance. We want litigation privilege when we file litigation documents. But this is going to be the fight I can't promise you that that ends one way or the other on the litigation privilege question, but I wanted you to be aware of its existence because there is likely to be at least a concern from the Lively side that using the California complaint is privileged documentation and defamation can't be brought against her for that purpose. All right. Following on from that, we also have more lawsuits. This is, thankfully, if you look at the top here, only a 10-page lawsuit, and we might cover it in a different video, but this is a lawsuit filed by Jed Wallace and his PR firm, Street Relations, against Blake Lively individually and nobody else. This was, if you remember back in the first video that we did in this series, the kind of shadowy figure that may or may not have done some social media networking for purposes of the shadow campaign against Blake Lively that neither Blake Lively nor the New York Times really knew what did. And he's suing essentially for the same kind of complaints, that defamation and otherwise being put out by the New York Times article that I think it's defamation. Let's see here. Declaratory judgment. He just wants these things to go away. And then defamation, yes. But we might cover this later on. It's a short document. Again, like I said, 180 pages, not the rule for what we're looking at here. This is clearly not written entirely for PR itself, but in order to get out in front of potential issues in the future. And that might be covered later on in Hangouts and Headlines. I might not cover that one in the future. We may be done with Lively Baldoni for a while. I'm not sure. Leave me a comment. Let me know if you'd like me to proceed with this. If you have other things you'd like me to cover, if you want a potpourri of facts and evidence that are otherwise being discussed on social media on this score. Otherwise, I just want to say thank you to everyone that supports this channel on Patreon with memberships and super chats. I do try to grab those as often as I can, including from special VIP guests like my dad. Wouldn't be here without him. Thomas Hoeg, thank you for the super chat. This doesn't look like a break to me. Please take care to give yourself enough of a rest. Hey, I love to talk about these things. I'm just finding my groove. So how Hoeg got his groove back. You are still recovering and we love you. Also, this has been a great analysis of Babies from Hollywood. I appreciate you, Dad. Thank you for the super chat. I hope you're having a great vacation. And I will see you again very, very soon. Against the Tide agrees that I am working myself too hard on these things. Guys, I know you said this before, certainly before the end of 2022. I am not going to flame out doing this stuff. I'm not going to kill myself, but I love having these conversations. I love doing these types of videos, and you guys make it all worthwhile. Thank you so much for being here against the tide. And A. Hettinger asking the important questions. Are we still going? Yeah, we haven't hit 3 hours yet. 3 hours was my get out time on this. So I'm actually really happy with the rate that we've gone through this. I was scared of this document, the 200 pages that Justin Baldoni and his team asked me to read. Not personally, but just in so filing. But I really appreciate having these conversations. And like the super chatters, like the members have shown here on this channel, I really appreciate that support. We're going to have more virtual legalities, short form virtual legalities. You might have seen Mrs. Hoglaw's 30 minutes or less badge that we were able to put on the most recent virtual legality that went live this morning. We're going to have more of those short form virtual legalities available for members first, to give that value to the patrons, to give that value to the YouTube members. And we're going to have more emojis eventually when I can find a good emoji purveyor to give you emojis, members, in the space as well. I may also do membership streams. I don't know. In the future, that's not in the plan right this second, but I intend to do that. I intend to make some new shows, and I intend to collaborate with some of my old lawyer friends even more as I get more used to being responsible enough, energy-wise, to be at a specific show at a specific time more often. So I really appreciate it from all of you. I can't say that enough. Maybe I say it too much already, but thank you so much for that support. And if you're not supporting financially, that is totally fine as well. Just subscribe, ring the bell, give the upvotes, tell your friends we're having these conversations, leave comments, enter into chat, do all the things that let YouTube know that this is a vibrant and robust community. And I really appreciate every aspect of all of that. Otherwise, let's see if I can grab any other super chats or member chats that I might have missed and take any questions or comments that you have in the chat at this time. All right, we did that one. I know we did Dad's. Weird Sister, thank you for being a member for more than a year. Hoeg, you're doing amazing, but please make sure you're taking care of yourself. I got my tea. It's not just for gossip in Hollywood. I do appreciate you all worrying about me. I am okay. I am very, very, very specific about not overtaxing myself. So thank you so much for worrying about me, but I am going to be okay. I appreciate that. Weird Sister says, I've actually been here since that first 10-hour live stream during Depp. Yeah, I will say this. You guys worry about me. That first headlines episode, I think, is 14 hours long. That's not going to happen again. I'm not capable of doing that again in the future. So I appreciate everybody's support. I'm probably going to top out at 3.5 on particularly long days. On the stream side of things, I'm going to try to make virtual legalities more often in that 30 minutes or less bracket. I feel like you get more information and more education and entertainment out of that anyway. So I'm probably going to try to make that more of the form going forward. And like I said earlier in this video, if you missed it, I am also going to try to make a really short form video series that may be more open to more controversial matters. Not that I will specifically be trying to be controversial, but to have my thoughts and opinions out there on matters that I generally try to avoid in virtual legality and Hangouts and Headlines. So stay tuned to that. All of that's possible by financial and other support of people like you. So if you're listening to this after the fact, thank you so much. Leave a review on whatever podcast service you're listening to it on. Right now, if you're in the chat, thank you so much for the super stickers. Jojo, thank you so much for all of this support and all the patrons that are out there. I intend to do one last question time when I can get the time to do it for those patrons, and then change the tiers up to more of what I can support here in 2025. But I really appreciate it from each and every one of you. Thank you so much for the emojis and all the support. And I think right now I'll see you on the next episode of Hangouts and Headlines or Virtual Legality, Bitcast, or whenever else I see you. Thank you. Thank you so much again.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.